My name is Charles Swanson. Today is October 4th, 2012, and I'm in Knoxville, Tennessee to interview Justice Penny White. This interview is taking place as a part of the Legal History Project of the Fellows of the Tennessee Bar Foundation in conjunction with the Tennessee Supreme Court Historical Society. Justice White, please tell us your full name and the date of your birth.
Full name?
Full
Penny
name.
Jo White, May 3rd, 1956.
Now, I've called you Justice White because that's who you really are. However, as you well know, I usually call you Penny, and throughout this interview, the likelihood is that I will call you Penny. I do not mean offense at that, but I just want you to be aware that I'm likely to do it.
Please do, but no Penny Joes.
I shall not do Penny Jo. Tell us about your maternal grandparents, Penny.
Well, my grandfather was a farmer in Southwest Virginia in a beautiful little town called Snowflake in Scott County. My grandmother...
What was his name?
His name was Charles H. Bush. My grandmother I barely knew. She was Ethel Bush, and she took care of the home place. My mother had two siblings, one of whom was Jo, that's my namesake, who died very, very young in life. And so my mother always said she was a farmer's daughter in every sense of the word. She did all the things that her brother couldn't because he was ill most of his life.
How about your father's parents?
My father's parents are from Greene County, Tennessee. Herman White was his dad, Herman Sevier White, also a farmer, but my dad's father also had a country store, the old-fashioned country store, mercantile store that he ran as well. And my dad's mom, Esther, was a, now that's completely bad, Etta was the name that we called her by, was a housewife also, in every sense of the word, a mother. My father is one of 12. So she, not all of whom survived childbirth, but she mothered all of those children and took care of her husband as well. For her pretty long life, she lived a pretty long life. My grandfather died young, however.
Now, your grandfather was Herman Sevier White? Was he named after John Sevier?
After John Sevier.
How about that?
And I'd always thought that would have been a nice first name, but I didn't get it.
Could have been Penny Sevier White.
That's right.
Too severe. Are your parents still living?
They are. My dad, Carmen, he goes by C.A., but his name's Carmen White, lives in Kingsport on his own. He is born in December 1919, so he's 92 and a half years old. And my mother, Jean Bush White, is also living, suffering from Alzheimer's and living in an assisted living facility near my father, but not at the house.
And when you were younger, what did your dad do for a living?
My dad, from the time he became a married man on, was an employee of Eastman, at that time, Bays Mountain Construction Company, which was a subsidiary of Tennessee Eastman. He was an electrician by trade, and that's what he did for Tennessee Eastman Company.
How about your mom? Was she ever employed outside the home?
She was. She stayed at home a lot, but she was really before her time in many, many ways. She was an architectural secretary. She prepared specifications on the old mag card typewriters long before anyone had ever thought of a computer, and detailed typewritten specifications for bids for architects, many architects in and around Kingsport. And she also worked for Kelly Girls occasionally between jobs. But my mom was really a prodigy. She finished high school at age 13. She was fully employed at the Clinchfield Railroad by the time she was 14. And she went to business college. So she was just really quite a woman before her time in a lot of ways.
So from the time you were born, you were aware that women could do lots of things.
That's the interesting thing about my mom. It wasn't just public work or secretarial work. My mom and dad actually built the house, not the house that I grew up my entire life in, but the house that we lived in from the time I turned 13 on. And when I say built, I mean they designed the plans, everything other than laying the foundation. They wired it, they plumbed it, they did it all. So she was far more accomplished in those things that are useful than I ever became, that's for sure.
Now, where did you grow up?
Grew up in Kingsport. The first 13 years of my life I spent in a wonderful little community called West Carters Valley, which is down near the Holston River in Sullivan County. In the 8th grade, the summer of the 8th grade, my parents moved us to the house that they built, which was a far nicer house, but it was a significantly difficult moment for that point in my life, to be uprooted from, a community where I'd grown up, where we all did everything together as a community, to this new, really nicer area in terms of affluent, but still a place that I didn't quite fit in. So that was a really difficult time for me.
So you grew up in Upper East Tennessee pretty much the whole time.
That's right. Just moved across county.
Penny, do you think that growing up in Upper East Tennessee played a particular role in the person you were to become later as an adult?
Definitely. I've thought a lot about in what way that happened, and really it sounds trite, but it comes down to 2 or 3 things. Growing up in Upper East Tennessee and in the kind of family I grew up in terms of economic status, which was just a working class family, I think I just grew up thinking that what you do is work. And I mean, that's good and it's bad, but we didn't have much play. I mean, I laughingly tell the story, it's true. We took, as a family, 1 week every year. We took the same week every year, and we went to the same place. Not only the same city, but the same hotel and the same hotel room every single year. But that was really significant because where I grew up, and this particular hotel was at the beach, Myrtle Beach. But where I grew up, most of the young kids I played with till I was 13 years of age had never seen the ocean. So really, we had it good. But what you did is you worked. When you got home from work in the evenings, you worked the garden, or you painted, or you washed the windows, or for crying out loud, you washed down the wood paneling in the basement. So part of growing up in East Tennessee was just instill that in me, that what you do during your life is you work. But I think the other part is kind of, it's almost like I guess the code of the hills or whatever. People were their word, people were their honor, and you grew up knowing that if you weren't truthful and honest and hardworking, that you wouldn't be respected. And respect was everything, to have people's respect for who you were, not for what you did or what you became, but for who you were. So I do think it was very significant in a good way. In other ways, it was detrimental. I grew up in a situation in which if we hadn't moved when I was 13, going to college would have been a reach. Not because I didn't have the intelligence, but because people where I grew up didn't go to college. They went to high school, they got a job, maybe they got their LPN license and became a nurse, but most people just didn't go to college, and I'm not that old. But I did get that opportunity, but the point I was going to make is that to go to a small local community college or a small college was good enough. We never dreamed about, I'll go to a top 20. We probably didn't know what a top 20 university was. So in some ways, I've always felt that my foundational educational background is a little lacking. The public schools that I went to were good enough, but they weren't great. And so very much it's a part of who I am, both good and bad. Long answer.
Good answer.
Hard
Good
question.
answer.
Hard question.
It explains to me that your work ethic that you demonstrated throughout your career really wasn't optional.
That's right, but it is sometimes a curse, very much so, a curse.
Now, where'd you go to high school?
In Sullivan County, Sullivan Central High School. Got started with the orange and white early because the colors for Sullivan Central High School were orange and white. It's in Bluntville.
How about your undergraduate school? Where'd you go there?
Yeah, and that fits into what I was just saying. I went to East Tennessee State University, and it changed who I was, and it gave me so much. But in all candor, at this point in my life, when I'm trying to be a member of the academy, having an undergraduate degree from an unknown university like ETSU can be a hindrance. But for me, it was more than a lot of people in my upbringing expected, so it worked out well. And of course, since we're taping this, and who knows what the future will hold, East Tennessee State University is in Johnson City, Tennessee, also in Northeast Tennessee.
And East Tennessee State, for many of us, is really not what we would regard as a small school. And of course, the University of Tennessee was reasonably close to your home as well. But you're talking about Yale and Harvard and those kinds of schools you didn't really think about.
Didn't think about, and I'll tell you why I went to ETSU, and it figures into someone who was prominent in my life, sort of didn't plan to be prominent, but he was a coach at Colonial Heights Junior High School. And he had gone on to become an admissions counselor at ETSU, and he came to Sullivan Central and said, if you make this score, and gave me a raw number, on your ACT, I'll give you a free ride to ETSU. I'll give you a 4-year scholarship. Well, true to just being, basically just getting there, I made that score,
that
not 1 point more. And he gave me a 4-year scholarship. And all of my friends at that point were coming to the University of Tennessee. But I knew financially that while my mom and dad would try to make it work, I couldn't even imagine going somewhere that you'd have to pay for if you had a 4-year scholarship. So I went to ETSU on a 4-year scholarship.
So what do you think he saw in you to make that kind of offer?
I don't know. I had only met him after we moved, and those were difficult times for me. So I don't know. I think he probably made that offer to everybody. I don't think it was. He probably would have given a scholarship to anybody who made that score. It wasn't a low score by any means, but I'm not sure it was unique to me.
When you were at ETSU, what was your major?
I majored in political science, very useful major, as we all know, right? I think by that time I knew I wanted to come to law school. So I majored in political science. Some people used to give that advice. I'm not really sure why. Had a minor in criminal justice, a double major in political science and criminal justice, and a minor in an even more useful discipline, speech.
It is a very useful discipline, I've discovered. They might not have thought so at the time.
That's
though.
right.
Now, somewhere I think I heard that you were pretty active in student government when you were in undergraduate school. Am I right about that?
I was. You can't ask me a question and just get an answer. I'd be a horrible witness, wouldn't I, Charles?
No, you're a good witness.
In junior high, during those difficult days, I had been persuaded to run for student government office by a different coach, not the one who offered me the scholarship, but a different one. And myself and 2 young women had done that, unheard of. 3 young women back in the 1970s running for the lead offices in the school.
Did you run as a ticket?
We ran as a ticket. We were soundly defeated by 3 men. In high school, the same 3 women ran against the same 3 men, and this time we won. So that was that was how I got involved in student government in high school. I was not a cheerleader. I was not a member of the band. There were almost no women's sports, so I wasn't involved in athletics. So I spent a lot of time devoted to student government, whatever that means at high school. When you're in high school, you think that's pretty darn important.
And did it carry over to college?
It did. It did. Unusual. I was not a member of a sorority. I ran, however, as a non-Greek for president of the student government at ETSU, and was successful. Not the same 2 women this time. I had a Greek guy as my vice president candidate, so got elected. And they say, it's one of those historical facts that's unproven. They say I was the first woman of this first woman student body president at ETSU. It's subject to being contested because there were times when ETSU was what they called the normal school and a teacher's college and only had women students. So if they had a government, they clearly had to have had a woman president before. But they acclaimed me as the first woman president there.
Now, you said that when you majored in political science, you sort of had law school in the back of your mind. At what point did you seriously think about going to law school?
8th or 9th grade. for no real reason. I'd never seen a lawyer, never seen a real lawyer, no lawyers in my family. Coach Roger Herron, who taught Tennessee history, had this way of suggesting and he would use the same quote to suggest his overall theme. His quote was, "Speak now or forever hold your peace," which he obviously stole from history. But his point was, you know, it's time, you got to do something or you can't complain about it, or you've got to, if you've got questions about this subject matter, ask me now or don't complain later. And I don't know, it just kind of instilled this sense of duty, I guess, in a way, for a citizen, for a public citizen. And maybe you get that if you're in the military, but I never had that opportunity. So something just stuck that, well, what can I do? And I didn't have a good, strong science background, so I ended up just beginning to say, I'm going to law school. Never, as I said, didn't know any lawyers, had none in the family, but that just became my career objective that early in life.
So when you were in college and going through that process, did you consider other careers as you were going along?
I really didn't. My mother strongly wanted me to be a nurse, and that was brought up to me often, but I really never considered it.
Now, where did you go to law school?
I came to the University of Tennessee College of Law right after undergrad. I spent a short period of time, 2 semesters, working on a master's degree, but really no meaningful career between undergrad and law school.
You graduated from Tennessee class of?
81.
Were you one of those people who enjoyed law school?
I don't know. I enjoyed aspects of it. But I don't really think I would say I enjoyed it. It was stressful. It was challenging. I thought it was very challenging. These students today that kind of breeze through, they just amaze me.
I also went to a small school, and I remember coming to the University of Tennessee being scared to death that I wasn't prepared to compete.
Yeah.
Were you concerned about that?
Absolutely. And I didn't come to law school with many people I knew. And I think, Charles, you had the same experience. The University of Tennessee divides you alphabetically your first year.
Right.
So you often become fast friends with people who are, in my case, the T's, the U's, and the V's, you know, and maybe a few X, Y's, and Z's along the way, because I was a white in law school as well. So you were looking, you know, in college you look around and you know these folks and you know how they've done and you know how you compare, but you're looking at a whole new world of faces. You don't know how you're going to compare. And of course we make it all the more stressful by giving one exam per semester, per course, so you don't get any measurement along the way how you're doing. So yeah, I found it very stressful.
That first semester that you were here, or first quarter that you were here, did you have a little concern that it was country girl come to town?
Absolutely, and that was so reinforced by my Legal Process 1 instructor, who informed me for the first time in my life that I did not know how to write. You know, I had taken a lot of writing courses with a great professor at ETSU. So then you don't know, did I really not learn how to write? Do I really not know how to write? Am I going to be able to get through this? Oh yeah, it was horrible.
Was it a huge relief to you when you realized you could compete?
It was, but I don't think it ever ended. Every semester or quarter, I would go, back in those days, grades were posted by exam number, and you'd all, you know, I'd drive down here on Saturday if we were on break. You'd get in the door as soon as the door opened and go look, find your exam number and see what grade you made. And sometimes it would be a fairly traumatic situation there in the hallway as people saw their grades. So yeah, and there were semesters when I was at the bottom of the barrel, and there were, fortunately, the others outweighed. But I had some rough semesters here. I remember going in to see one professor and I say here because we're at UT today. But I remember going in to see one professor about my grade afterwards, and it was Durwood Jones, and he just put his head in his hands and he said, I don't know where to start. I just can't help you. Therefore, I did not become a tax lawyer.
Well, Other than Professor Jones, who are the professors at UT that you remember who were sort of memorable to you in your law school career?
By far the best was Professor, and still is Professor Joe Cook. Had him my first quarter, my second quarter, and then took him every single time I could get him, and ended up probably taking 6 or 7 courses from him. Ended up being his research assistant. He intimidated me to death, and he still does. I live for the day that I can get Professor Cook to smile at me in the halls at UT, still today. He is just a giant academically, and a fabulous teacher. So by far my most memorable professor.
So you finished law school in 1981. What was next for you?
Well, I finally got a job, and I say that in all honesty. It was April. We then graduated probably around the end of May on the quarter system, and it was the 3rd week of April. I almost want to say I remember the day that I finally got an interview with the job I took, and that is not to suggest that I had a number of other interviews. I have all, you talked about East Tennessee having a bearing on my upbringing or on my life. It is a magnet. East Tennessee drags you back. So something told me I had to practice in Upper East Tennessee. So I narrowed my search to there, and I met with a lot of firms who did not have women, who did not want women, and who did not want me. And I remember one conversation in particular with a large firm in Kingsport, sitting across the table from a man, and the first words out of his mouth being, "We both know this is a waste of our time." And so I had a really difficult time getting a job. Now, I was editor of the Law Review, and I graduated high in the class, but I could not find a job. And so this is, I think, helpful, I hope, someday to somebody who's in the same sort of situation. What finally happened is a man who I had worked for 2 summers earlier, who had been legal aid director, and I'd worked for him as a summer clerk. I called him and I said, "I want to go to work for Dick Pechtel, who is a lawyer in Johnson City, and I can't get," I'm sorry, Dick, but it's true, "I can't get Dick Pechtel to return my calls. Can you help me?" And after about 3 or 4 weeks, he got Mr. Pechtel to agree to see me. I went up there and interviewed, and he offered me a job. So it all worked out in the end, but it was horrible. I didn't know what I was going to do. So I know I can so sympathize with people nowadays, the last 2 or 3 years law students who are getting out and not knowing what they're going to do career-wise. So again, sorry, but long story short, I went to work for Richard Pechtel & Associates as soon as I got out of law school, after I took the bar, and it was a small shop, 3 people. Mr. Pechtel, myself, and another associate.
Do you recall whether or not there were other women in your class who had the same sort of difficult experience in being placed?
I don't. I know that a lot of people stayed in Knoxville, and a lot of people went to Nashville and to Memphis, and I feel like their experiences, and I feel like it was easier. I feel like Upper East Tennessee was one of the last places to have lawyers. Now, there were 6 phenomenal lady lawyers. I hate using that phrase, but I'm using it just to be specific here. Women who happen to be, or lawyers who happen to be women, up there at the time. So I certainly wasn't the first, but a lot of them were on their own. The one name that comes to mind right away is Judge Sharon Green, who's juvenile judge there now. She was practicing with her father. Another name that comes to mind is Margaret Fugit. She was up there and she was practicing with, I think, her then husband. So it was a little different. I wasn't going in with a family firm, wasn't going in with my spouse, and I was going to rural East Tennessee.
So you engineered the interview with Mr. Pechtel.
That's a very nice way of putting it. I did finally.
Why did you engineer that interview? What was it about that firm that made you?
I admired him from afar because of his trial work. All I really wanted to do at that time, all I thought I wanted to do was criminal defense. And I admired who he was in the courtroom and the kinds of cases he got. So I just basically honed in on this is who I want to go to work with.
Once you got started, what sort of work were you primarily doing?
I was carrying a lot of briefcases. But I had a wonderful experience. Within 10 days of going to work with Dick Pechtel, we took a first-degree murder case that I would work on from September '81 until 1989.
Wow.
Through a trial and appeal, my first trip to the Tennessee Supreme Court, a reversal, a new trial, and an acquittal. So a case that lasted almost the entirety of my private practice career. So we did a lot of criminal defense work. We did some. He did a fair amount of tort work, and I got introduced to family law for the first time as a young associate in his firm, and that's an area of law that I came to enjoy. Seems like a strange word to use, but it's an area of law that I came to feel very useful in as both a trial lawyer and as a trial judge because of the depths of despair that people are in. It's similar in some ways to criminal because people are really in need of your help and counsel. So I did a little bit of what I always call, walk in the door people law, just helping folks with the problems that they have.
You thought you were going to enjoy criminal defense practice. Did it turn out that you really did?
Loved it. Yeah, absolutely. No question. I'm still an old criminal defense lawyer at heart.
What is there about the criminal defense practice that draws you?
Protecting what could just be lofty claims of privilege and right, protecting those and making sure that they're actually honored, particularly in a dynamic where one side has all the tools and all the resources and the other side doesn't. I guess it sounded like I'm saying the David and Goliath nature of it, although I don't want to compare David to criminal defendants, but basically that's what I'm talking about is that, you're going up against the government and all its power, and they've proclaimed these rights that they're going to give to individuals in this situation, and it's just so easy to let those fall by the wayside. So just being the person who says, no, wait a minute, that's not the way we do it. Just being the voice for someone who a mighty force is coming against.
You enjoyed being a part of the essence of the rule of law.
Yeah, that's very nice. Again, very well put.
Now, how long were you with Mr. Pechtel?
I was with him 2 years, from '81 till the end of '83, or till the summer of '83.
And then what was next?
I was learning a lot, but no one was ever going to walk in the door to see me. And I was always going to carry a briefcase, and I just didn't have it in my gut, in my soul, to carry a briefcase forever. And while I was at UT, I had taken a number of legal clinics, and as a result, had gotten to know some of the legal clinic professors here, who were also memorable. I didn't mention them earlier, but they were memorable. But out of the blue, one of my former law professors, Dean Rivkin, contacted me. I ran into him or something. I don't quite understand or remember what, but he said, Penny, there's this program up at Georgetown Law School, and you'd be great for it. And it was right about the time I was getting antsy and wanting to do a little bit more and realizing that I wasn't going to get to. So I remember that the timing was such that the application was due. I mean, it was pretty dramatic, but I managed to get the application done. Was also,
the application for?
I'm sorry, the application to go to Georgetown Law School to participate in this so-called E. Barrett Prettyman program, a fellowship program. And it was complicated by the fact that I was also getting engaged at about the same time. And the person I was becoming engaged to lived in Tennessee, and of course Georgetown Law School is Washington, D.C., and there were all these complications. So I applied for the E. Barrett Prettyman Fellowship and sort of forgot about it, and then lo and behold got an interview and got the offer. And it was fabulous. They'd never taken anyone from the University of Tennessee before. They only choose 5 a year. It was fabulous. But now what am I going to do? I've got this guy in Tennessee. I got this offer in Washington. Ultimately, we decided that we would move to Washington and I would take the opportunity to be an E. Barrett Prettyman Fellow. So I went up there for 2 years and it definitely changed my law life because of just the in-depth, intense training that you go through in that program. It is geared toward training clinical law professors. The program was funded by E. Barrett Prettyman, who was a district judge in the District of Columbia, who I guess borrowed Chief Justice Berger, I think it is, phrase that many lawyers were walking violations of the Sixth Amendment. And he said the way we're going to make lawyers not be walking violations of the Sixth Amendment is we're going to train them in law school to be lawyers. Imagine that. So he put this money out to fund this program so that people would come to Georgetown and learn how to be clinical teachers. So that was the basis of the program. But the backdrop is that you represent
Let me interrupt you
clients.
there, and let me ask you this. You talked about walking violation of the Sixth Amendment. I want to hit that because was he talking about the effective assistance of counsel and the
Absolutely.
lack of that?
Absolutely. And this was in the 60s. This was long before we had any, had the sort of modern jurisprudence that we have on the effective assistance of counsel. So he funded the program to train clinical law professors to go all over the country and prepare people to be good criminal defense lawyers. So the program at Georgetown does just that. It brings 5 people in a year so that there are a total of 10 fellows at any given time because it's a 2-year program. And these people learn to be clinical law professors while representing indigent defendants in the courts in the District of Columbia. So I did that for 2 years under the tutelage of Bill Greenhall, a fabulous professor at Georgetown Law School, and learned about turning every stone when you're representing a client, about looking everywhere, looking under every stone, looking through every door, doing everything possible to render effective assistance. And it changed the way I thought about the practice of law, or it changed the magnitude with which the responsibility for representing a person in a court. It changed my idea of the magnitude of that responsibility.
When you were doing that, when you were serving as a Prettyman Fellow at Georgetown, did you realize while you were doing it how much fun you were having?
Oh no, this was the worst because being the only Tennessean, they made fun of me from the day I got there. They made fun. At that time, I was a little modest. They made fun of the way I talked. They, being my fellow fellows, they made fun of the way I talked. I remember being laughed at McDonald's trying to order food. I had never lived away from East Tennessee, and I felt like was sticking out like a huge sore thumb in terms of being, that country bumpkin or whatever. But my fellow fellows would use some salty language and look, and I would blush, and they laughed to this day. There was an article written at one point in my career about me in which one of the fellows said that we cursed just to watch her blush. I mean, they took advantage of my naivete at every level. And it didn't help that Greenhall said the reason he had offered it to me is because he thought I sounded like Dolly Parton. I mean, so that didn't really build my confidence. But no, I didn't know I was having fun. I did not know I was having fun, and I didn't know it was changing my life. But I was working hard.
But in retrospect, were you having fun?
Oh yeah, what a great experience. And I'm happy to say that they've now had 2 other Tennesseans. So there have now been 3 Tennessee Prettymen in the course of the program. One of them is a very recent grad, so we're proud of that.
You taught them what Tennesseans could do,
That's
didn't you?
right.
Now, did you do any academic, I know you were working in the clinic, but did you do academic coursework at Georgetown as well?
Yes, each fellow had to take only 12 hours of classroom study, and those were 6 hours were dictated. One was a pedagogical course on how to design clinical teaching and so forth. The other was a intensive trial training course, and the other 2 were at your choice. So you took whatever master's level courses Georgetown Law School had to offer that interested you. And then if you desired to get the degree, which it wasn't mandatory at all, many people don't, but if you desired, then you had to write a dissertation. And what would be a better topic than the right to counsel, which is what I wrote my dissertation about.
a logical thing, I think.
That's right.
Have you been able to stay in touch with your fellow fellows, as you refer to them?
Yeah, I actually have. We have reunions, so it happens occasionally. I tell you, I've stayed in better touch with the staff. There were two administrative secretaries up there who I still, every time I go to D.C., I go over to the law school just to say hi to them because they're still around. So I maintain some contact with them.
Now, I see on your resume that you have a Master's of Law degree from Georgetown University. Is that the natural outcropping of the Prettyman Fellowship?
That's right. Upon completion of the dissertation, you get the LLM in advocacy.
Now, did you come back to East Tennessee when you finished your fellowship?
Yeah, that magnet just drugged me back. I applied for teaching positions, which was supposed to be the natural evolution of what you do next after you get that LLM. I got a few offers, none of which interested me. So I came back and I rented an IBM Selectric 3 typewriter from Mr. Pechtel. And I took my last Prettyman check, and we made $13,000 a year. So I took my last Prettyman check for $1,100, and I rented a room, and I nailed a shingle up, and I started practicing law.
Solo
On my own.
practice. What type of law did you practice? What did you
Anything
do?
that walked in the door. I did a lot of family law. I did a lot of court-appointed work. Back then, we did not have a public defender system. That's what I'd actually written my dissertation about. So I took a lot of appointments, just showed up at the courthouse, got the appointments. I did work, I let the law firms in Johnson City know that I was available if they didn't want to write a brief or if they had a conflict in a case. So I took referrals, tried to get referrals, and ultimately grew from that one-room office to a couple-room office, and then ultimately bought a building for my firm.
Were there other women who were solo practitioners in your area?
Probably. Can't think of anybody right offhand, but probably, because if you can't get anybody to hire you, that's what you do. I'm not saying that was my situation at that time, but at that time, when I started my own practice, I wanted to practice on my own. I wanted to be in charge of taking the cases and deciding how things were to go. But you know, obviously, as I think a lot of people are finding out these days, that is one avenue for people who don't get offers.
Did you take a lot of appointed work at that point to build a practice?
A lot of appointed work, criminal, and interestingly enough, the legal services office, where I had worked after my first summer in law school. At that time, legal services was structured a little differently from what it is now, in that they could take cases that might generate fees if they were successful. Nowadays, they don't do that. But they had taken on some cases, particularly involving jail conditions, that were becoming overwhelming to them. And so within a short amount of time, they contracted with me to do the trial work on those jail condition cases. So I began to develop a specialty in civil rights litigation, in jail conditions law, and in prison litigation. And that, again, was before the reform of the Prison Litigation Reform Act, which has pretty much stamped out a lot of that litigation. But I was getting a lot of federal court work by virtue of those referrals from legal services and that contract work from legal services.
Do you think your experience at Georgetown gave you some confidence to come back and go solo that maybe you didn't have before?
I think that's likely. Yeah, I think that's very likely.
So I'm told, and I think I've heard this right, that you are one of a small group of lawyers who has argued a case before the United States Supreme Court. Now, is that right?
That is correct. Just one.
It's one more than I've had in a career. When did that happen?
Let's see, 1988. Didn't I figure that out? Yeah, 1988. So I got back from Georgetown in 85, started my firm in 85. And 3 years later, it's, I need to answer your question, but I'll tell you, it's an unusual connection to what I just said. Some of the jail litigation that I got involved in was successful and settled, and some of it was tried. And one of those cases that we tried and were successful in was appealed to the Sixth Circuit. And at the time, the Sixth Circuit Court of Appeals in Cincinnati. And at the time, I was not licensed in the Sixth Circuit. So I filled out an application to be licensed. It's simply a matter of filling out an application and paying your money. But on the Sixth Circuit application at that time was a little block that said, will you accept appointments? And I, of course, checked yes. And within literally a few days, I got an appointment from the Sixth Circuit in which they were asking me to look at a case in which the pro se petitioner had filed in district court, lost, and appealed to the Sixth Circuit. And they believed his appeal to be out of time. They believed it was late. So they appointed me to brief whether his appeal was late on behalf of Prentice Houston, was the petitioner's name. Right. So as a result of that appointment, I did what I had to do in the Sixth Circuit. I went to the Sixth Circuit. I stood up to argue the case, the first time I'd ever appeared there. And before I got literally, my name is Penny White, I'm a member of the Tennessee Bar, I noticed that the three judges began talking, which I thought was pretty rude. You know, I'd come all the way to Cincinnati. I probably had a new dress on or something, you know, new suit, and they're talking, looking back and forth. And finally, the judge in the middle said, Ms. White, you know, pursuant to Internal Operating Rule 16, and because I'm obsessive compulsive, I had read all the rules, so I'm going in my mind, 16, which one's that? And about the time he said it, I realized that he said, we summarily affirm the dismissal of this case. We do not need to hear your argument.
Oh my.
So I'm shut down immediately before I even get to make my argument in the Sixth Circuit. Well, unfortunately, they had another rule, and it said if you're appointed, you must petition the United States Supreme Court for certiorari. So I did, and they granted it. Now, you can't make this stuff up. So that was how I got to the U.S. Supreme Court.
How old were you at that time?
32. 32.
And you'd been practicing law at that time for 7 years?
Yeah, about 7 years. Yeah. You know, when you, so you petition the court and the court grants cert, but then that still doesn't, so you can be the lawyer then, obviously, because you filed the cert petition, but it's expensive to appear in the U.S. Supreme Court in the sense that you're expected to print your briefs and it's time consuming. So I wrestled with myself for a while about whether I wanted to request the U.S. Supreme Court to actually appoint me, because once they do so, they will pay for your printing cost, and they will also pay a small fee for your representation. And I had been advised that there were a lot of people who wanted to be appointed to argue in the Supreme Court. And bear in mind, this is way before the development of this sort of boutique Supreme Court bar of these people who do all the arguments in the Supreme Court. This is when an everyday Penny White could still end up in the Supreme Court. So I went back and forth in my mind, and eventually I decided I cannot afford to do this without being appointed. So I made the motion for appointment, and Chief Justice Rehnquist appointed me, probably because it was so close in time that someone else wouldn't have had an opportunity to get up to speed on it. So I ended up getting appointed by the Supreme Court, but that was after the petition had already been filed and accepted.
So you're a 32-year-old lawyer in front of the United States Supreme Court. Who do you go to say, what do I do?
I came right to this building, the University of Tennessee College of Law, and I went right to Georgetown. And I also went to the hills of Upper East Tennessee. I did 3 moot courts with the UT law faculty, with the Georgetown law faculty and the Prettyman people, and with the lawyers of Upper East Tennessee. I did three practice moot courts.
And how long was it before you actually had your oral argument that you knew that you were going to be arguing this case before the United States Supreme Court?
It's also a very unique situation. They granted cert in my case over the holidays in December. and late December, maybe even the first week of January. And my oral argument was April 24th or April 27th. It was the last day of the term, so I believe it was April 27th. So we were the last case to have cert granted and the last case to be argued, so there was about a 4-month period. And in that time, there was also a brief that had to be filed, a merits brief and a reply brief. So it was really a short timetable.
When did you ever sleep during that period of time?
Yeah, I
Were
don't.
you trying to maintain the rest of your practice at this time?
Yeah, I was, but not so much. I certainly wasn't taking anything new at all.
Do you know how much you got paid for this effort?
Yeah, I got $500. I got $500.
If you would, think back to the day of the oral argument itself.
I hate
remember
to
what you
admit
felt
it's
like?
so easy. I can tell you everything about that day.
Tell me how you felt.
Oh my gosh. Scared, awestruck, after it was over, relieved, exhilarated. I had these anecdotes may get old, but this is one that I can't not tell it. I had a new pair of shoes. I was going to the Supreme Court. I probably had a new everything. And I had walked from the hotel. And I had worked a groove into the back of my foot so deeply that I was bleeding. Well, the Supreme Court has its own nurse. Who would have known it? So when I get there and I check in, I'm the last argument of the day, but you have to check in the morning. So I check in and then I go to the cafeteria, and I have sort of a disrupting situation in the cafeteria. I kind of drop my tray, and Justice Blackmun is in the cafeteria with his law clerks, and he sort of looks over at me like poor pitiful creature kind of look. So anyway, I get all put back together, and someone says, you need to see the nurse. You've got blood up and down your leg, up and down your stocking. So I go to the nurse, and you'll see why this is an unbelievable story. So she takes care of me. She cleans my stocking. She bandages me up. We get to talking. She is Elsie Range. She is the wife of Harry Range, who founded the Range Medical Clinic in Johnson City, Tennessee. I mean, it was almost like an angel, So she's so kind and so gentle. So I go through the rest of the day. It's time for me to argue. And what I remember seeing out off my right shoulder when I stood up to walk up to the table was Elsie Range standing in the back of the United States Supreme Court. And I don't know whether it was that or one of Justice Blackmun's opening questions. One of Justice Blackmun's opening questions to me was, I've never quite felt that we treated poor people fairly in this court. And that was the essence of my opinion. And from that moment on, I just felt buoyed with strength and compassion and just with guts. And my professor, who I mentioned a while ago, Bill Greenhall, came to observe, and he said to me, the first thing he said to me after we left was, "Has Blackmun proposed yet?" And it was weird because he gave me a gaze of encouragement from that question on, and he really turned out to be an incredible force. My father, after I went on the bench, wrote him a personal note, and Justice Blackmun wrote him back. And so I've just always felt this unusual connection with him. But clearly, not all of the argument was peaceful. It was a pretty vigorous debate between Justice Scalia and myself, a pretty heated debate, which Blackmun ended up describing as being like a fight. So I guess from the observer's point of view, it was pretty vicious. From my point of view, it was like that. I stood up, I spoke, I sat down, and the fact that I didn't pass out in the middle, I consider an extreme accomplishment, and that's how it felt. It just buzzed by. So it was, I never wanted to do another thing. I just wanted to go home, put my feet up on the couch, and think about it the rest of my life. It was a great experience.
Now, I've heard that the press reported, after your argument there, the press reported some feedback about your performance in the Supreme Court. Do you remember That?
You're trying to make me look so immodest.
I'm doing my best.
I do remember.
It's hard to do.
But it too came about in a roundabout way. I got a call in my little office in Johnson City from a woman who claimed she was a member of the D.C. Bar. Don't remember her name, but she said, I heard Justice Blackmun give a speech today, and he mentioned you personally, and I just thought you wanted to hear about it. Well, I thought she was one of my Prettyman colleagues pulling my leg.
Right.
So I said, yeah, right. And she got a little bit offended and basically hung up. Well, as it turned out, that had happened. Blackmun had been given a talk at a meeting. I think he did it more than once. And he was using my argument as the backdrop to complain about Justice Scalia's uncivil treatment of litigants of advocates before the court. And so Justice Blackmun compared Justice Scalia and I to fighters, and basically the way he described it, I got the better of Scalia in the end. So it made news, and then I just
made news in the New York Times, didn't it?
It made news in the New York Times, yeah, it did. But then, the amazing thing is 20 years later, they repeated it in the New Yorker magazine. So like I said, sometimes sometimes I just get great things happening to me for no reason whatsoever. But yeah, it was, I don't know that the argument was as good as Blackmun has made it out to be, but it was nice to have that happen, obviously.
It's good enough to win, wasn't it?
Yeah, 5-4 with Scalia dissenting.
So could you have predicted in advance that this was going to be a 5-4 opinion in your favor?
I couldn't. And I think historically we've become much more attuned to predicting how justices will view based on what we think their personal and political philosophies are. I did not have that knowledge of the court at that time, nor do I think we had that tendency, we being meaning lawyers, we did not have the tendency so much to predict. But I will tell you this, and this was shared, this I learned not through my own knowledge, but through my then husband. Brennan wrote the opinion, and I was told that meant that it was a struggle. For Brennan to actually write the opinion probably means that's who had to write it to get the 5th vote. But let's not make it bigger than it was. The New York Times said it was the least significant case of the term. So we don't want to create any misimpressions here that we did anything really significant. We did get through it.
How significant was it in your career when you got back home?
Yeah, well, like I said, I didn't ever want to do anything else. I doubt that many people in Tri-Cities knew about it or know about it, but heaven knows I'm proud of it. I'd love to go back. I've tried on 2 occasions to go back, and both times they've denied cert, but I would love to go back.
I would think that when you win a case in the Supreme Court, the lawyers in your area are going to send you some business. Did you think that happened?
I don't. But then again, the opinion came down in mid-'88. I practiced another year and a half, and then I started running for the bench. So, no, I don't really think it brought me business. But I also don't think it got near the publicity at home as it got afar.
Was it in the Kingsport papers?
Not that I remember.
So it made the New York Times, but not the Kingsport Press.
I don't think it made the Kingsport Times or the Johnson City Press. I could be wrong about that, but I don't remember it. The decision came down while I was out of town, so maybe that was it. I just remember we were out of town when we learned that the court had ruled. So
having capped your career at the bar, you decided it was time to go to the bench.
No, you know what made me decide it was time to go to the bench was...
What did?
Well, I actually, 2 things. One thing, because of the wonderful experience I had at Georgetown. When I was at Georgetown, I was practicing in Maryland, so I was probably appeared before 60 or 70 different judges in the metropolitan counties surrounding the District of Columbia. And then coming back and practicing in a lot of Northeast Tennessee, not as far down as Knoxville very often, but occasionally. I had been before a lot of judges, and I just felt like that there could be some improvement in the administration of justice. And in particular, and the second reason, I was tired of being treated differently because I wasn't a man. I was tired of appearing before jurists who seemed to still not get it that women could be lawyers and could be good lawyers. I won cases because judges treated me poorly, don't get me wrong, but I just decided there needs to be some improvement in the administration of justice. And I'm not suggesting it's any one person on the bench or any one person but I did see a great deal of difference in the judges in Maryland where there was great diversity on the bench, gender and ethnic and cultural diversity, and the judges of East Tennessee. So I just decided I think I can make some improvement here. And I also was a little weary of the difficulty of having a solo practice, of running it on your own, never being able to be away, always being worried that something was going to happen. Plus, I was a workaholic, so unfortunately, I had made the wise decision to put my office in my home, so if I heard the phone ringing on a Saturday afternoon and I knew some huge crime had been committed on Friday night, I was going to go get that phone call, you know. So I needed to make a change in my life.
Now, were you a part of that first sort of large wave of women coming out of law school that
Probably
more heavily populated the bar with women lawyers than before?
Yeah, probably. I think the number that sticks in my head that makes it easy to put in perspective is when I became a trial judge in '90, there were 9 women trial judges in the state of Tennessee. 9 out of what was then about 180. And I'm talking about courts of record, so I'm not counting Sessions Court. But for the courts of record, there were 9 women at that time. So the number of lawyers obviously was proportionately small.
Well, we've been talking for about an hour about your career. Let's come back in a few minutes and talk about your career on the bench.
Okay.
Just before the break, we were talking about you making the transition from practicing lawyer to the bench. And in 1990, you made that first transition from your law practice. Was that part of a long-term private plan that you had, or just a whim?
Well, it wasn't a long-term private plan. It was a 6 to 9 month decision-making process, partially motivated by the fact that judge in the First Judicial District, which is Washington, Carter, Johnson, Unicoi counties, had announced his retirement. And it's not any secret to most people, most lawyers in Tennessee, that it's hard to run against an incumbent. It's always better to run for an open seat. So once Judge Jack Musick announced his upcoming retirement, I started thinking about it. And that was, well, I remember precisely that it was in the fall because we were traveling to Don Payne's TLI program when we began to talk about it, some of us in the car, and made the decision about then, so that would have been September or October of '95, and then the election was in August, of 89, excuse me, and then the election would have been in August of '90.
Was it a contested election?
Oh, it was, very much so.
Do you have any good election stories you can tell us?
I have some good election stories. It was my first foray into politics of organized kind, which is not to say that judging is politics, but getting on the bench certainly is. So I borrowed a pickup truck and put some sideboards on it with a hand-painted Penny White for judge. I traveled the 1,200 miles of the First Judicial District, literally knocking on doors, and we had a brigade of individuals who would meet on Saturdays for breakfast and go out and knock on doors for months, literally, trying to cover as many houses as we could. This was pre-Google, pre-everything, and so we had spent literally days going through the voting records of all 4 counties to identify frequent voters, and then taking maps of all 4 counties and by hand figuring out which were the best walk routes to hit the most likely frequent voters in the few hours you would have on Saturdays. Lots and lots of pancake breakfasts and ham suppers and lots of political etiquette issues. For example, in Upper East Tennessee, you don't campaign on Sunday. You might visit another church besides your own, but you don't knock on doors on Sunday, or at least you did in 1990. I guess a good story. I mean, you can't hide the truth. It's a little nasty, but my opponent was a married man with 2 children, and he was coached well by very powerful political people, including Lee Atwater.
So were these partisan elections? Were party politics here?
Not in name, but everyone was well aware of the political alignment of my opponent, and everyone presupposed my political alignment. So we did not have D's and R's on the ballot, but people identified the candidates as either a D or an R. So his campaign slogan was traditional family values, and my campaign slogan was the qualified candidate. And some people have suggested to me that was arrogant, but my point was I had counted every case I had ever tried, and I had counted every case that was of record, and I had counted every case he had appeared as of record, and I used graphs, and he was a real estate lawyer, so it was disproportionate. So I was saying that I was a qualified candidate. Well, anyway, on one occasion, he was giving a talk in which he indicated that I was unqualified for the bench because I did not have children. And I was there, and my then spouse was there, and I was, to use a country phrase, blowing a gasket. I was about to come out of my seat. I was so angry. And my then spouse was patting me on the knee saying, keep on message, don't lose your calm. So I got up, I ignored what he had said, and I gave my stump speech. The next night, there were 2 political events, probably 2 Ruritan Club meetings or something like that. So I went to one and my spouse went to the other. And the word travels back to me that when he is addressing the crowd on my behalf, he tells the crowd that he would like to address the fact that my opponent seems to be suggesting that since my ovaries don't work, nothing else must work either. So he is here's the man going crazy over the criticism of his wife after he had told me basically to stay the course, keep the stump speech. So my opponent tried very hard to make a big deal out of the fact that I didn't have children. And if you don't have children, you can't be smart enough to be on the bench. So that was kind of the theme of that campaign. There was another occasion in which the local radio station had a call-in show, and someone called in to ask whether either of us had ever used recreational drugs, kind of taking after the old United States Supreme Court confirmation. And my opponent at that time suggested that we should all reveal our pharmaceutical records, to which the radio commentator said, well, this is 1990. He said, well, I don't think many recreational drugs are drugs that you have prescriptions for. So it was a very heated, ugly campaign, but I guess for that campaign I would have to say all's well that ended well, so we came out all right.
Do you recall how much you had to spend in that election?
It was in the neighborhood of $30,000. It could have been $35,000, but it wasn't much more than that. This was a 4-county race. There were some television advertisements. There were obviously some radio advertisements, but money was spent on things like, yard signs, billboards, and cards to hand out, and bumper stickers. So it wasn't a huge amount like we see on television advertising today, but there were some TV ads.
Do you have any concept of what it would cost to run for a contested circuit judge seat in that area today?
Probably 200, maybe $250,000, depending on how contested it was and how many contestants, I guess.
So, after you were elected as a circuit court judge in 1990, were there other women in that area serving as trial court judges as well?
The closest female judge was Judge Mary Beth Leibowitz here in Knox County at that time, and that was, you know, that was another difficulty of the campaign. When I got married, I kept my father's name. I kept the Penny White name. I practiced under that name for some years, and my spouse was often, you know, with me and therefore called by my last name. And that's just kind of a thing of the times back then. People didn't expect women to have a different name, and he always had a very good response. He always would say, "I have my father's name. I don't see why she shouldn't have hers," which I thought was quite classic. But no, women were an anomaly in political office at that time. Now, you said trial court. Judge Shirley Underwood was a judge at the time I became a judge, and many years before I became a judge, and many years after I ceased to be a judge. So there was a woman judge. She was a juvenile court judge, but she was selected by a different process.
When you took the bench, I've always heard judges say once they took the bench, their jokes became funnier and they became smarter. Did you perceive that you were treated by members of the bar any differently than other trial court judges because you were a woman?
I think any new judge is subject to being tested by the advocates to see how far they can push and how much control, not all advocates, but some advocates, and how much control the judge is going to be exerting over her courtroom and over the process. I had only a couple of very insignificant incidents in which I think that treatment was related to gender. But I do think that, like any new judge, I was subject to being tested. And I tried very hard to be aware of that and not, you know, and keep enough control to be the judge, but not be overpowering or overbearing.
So did you have any special training when you took the bench?
You know, don't you know they lay you down and they take that syringe and put wisdom and patience and everything else into you when you become, and the ability to decide who's telling the truth and who's not telling the truth. No, I felt like I had on-the-job training by having been before some really, really good and some really, really bad judges. And I felt like I'd been before a variety of judges, more than a lot of people who hadn't had the wonderful opportunity I'd had to practice in a metropolitan area like the Maryland suburbs around D.C. But the real on-the-job, the real training came, and I would have to say my hat would have to be off to the Tennessee Judicial Conference. Once you become a judge in this state, and in all states really, you attend 3 or 4, maybe more, legal education or judicial education programs, and not only are you being taught, but you're also networking with. You're meeting those people who you can pick up the phone and call. We had a mentoring judge program when I went on the trial bench. I had a wonderful mentor judge, George Garrett from Sullivan County, who died way too early in his life while he was my mentor. But you were connected with someone, either formally or informally, who you could call and ask, and you were also going to education programs 3 times a year, and to the National Judicial College, which is where I also went as a young judge and got quite a bit of training, and I'm still associated with that institution to this day, 22 years later, even though I'm no longer a judge, as one of their faculty members. So the opportunities really come post-election, but there are many opportunities to help you be a better judge once you become a judge.
Now, you were only on the trial bench a couple of years. Do you have any really unusual or memorable cases that you can tell us about during that time?
Yeah, I do. I'd like to tell you about 2 if I could. One's very short. one of the things that you want not to do as a trial judge is for things to become routine, particularly things that are routine. In other words, uncontested divorce day may be a day where you hear 100 or so divorces, and for those people coming in your courtroom, that may be the only day they're ever in court. And it's so important for them to feel the sense of justice and the sense of formality and everything that we want people to feel about the court process. But it's also very easy if you're hearing the same memorized questions 100 times a day to not even look up. So I always try to be aware and to look up and to eyeball the participants. And on this particular day, it was Carter County. This could not happen anywhere but Carter County. Maybe we're halfway through the day. I don't recall exactly, but I had this book that I wrote down every case I heard in, just to make a note so that I would remember once the judgment or the order came in that I had heard that case, just as a safety valve, pre-computers again.
Let me interrupt you 1 second because you referred to Carter County, and for the folks in West Tennessee, they may not realize the rural aspect of Carter County. How would you characterize Carter County?
Oh man, you just got to go there. So Carter County is Elizabethton, Tennessee, and it's beautiful. It's a little mountain hamlet.
But predominantly rural.
Very rural, and it's just unusual. You just got to go there.
I'm sorry for
No, that's
interrupting.
quite
Now tell
all
me
right.
about your case.
Actually, Judge Robert Taylor was from around Carter County, the federal judge. But so we're on maybe divorce number 50. I don't know, irreconcilable divorce. And in those days, the words were basically, or the phrases were basically, you filed for divorce on the grounds of irreconcilable differences. You've signed this marital dissolution agreement. Do you think it's fair and equitable? Do you want the judge to approve it? Bang, that was it. You're divorced. So we get to the third question. You've signed this marital dissolution agreement. Do you think it's fair and equitable? And the woman says no. So I'm looking down, writing, and I look up and no, and her lawyer says, you don't think it's fair and equitable? And she turns to me and she says, no, not given the lying, cheating son of a bitch that he was. So I bound back in my chair a little bit further, and the lawyer coughs or something. He says, well, do you want the judge to approve it? And she stops and she looks at me and she says, Your Honor, can you award body parts? That, was like, I think it's time for a recess. But that's only Carter County. But my other favorite story, I think it's good for judges to always bear in mind that they cannot take themselves so seriously. And this was early on in my judicial career. I had Johnson County. Johnson County is Mountain City. It is the northeasternmost part of the state. It is, I've always been told that it's closer from Johnson County to Canada as the crow flies than it is from Johnson County to Memphis. So that gives you a sense of the state. And let's say we said Carter County was rural. Let's say that Johnson County makes Carter County look very metropolitan. So I had Johnson County in January, and I don't care what the weather is. It's going to take you an hour from Johnson City to Johnson County if you're making good time. It's very narrow roads, windy roads, beautiful mountain roads. So when I get to court that January, it turns out that the county commission is using the courtroom. Now this may have been a situation where if I had been a male judge, that wouldn't have happened. I've never thought about that before. But when I got there, they just basically said, well, Judge, we have a county commission meeting. So you're in this conference room. So I didn't push the issue. Maybe I should have, but I knew that I was going to have to do certain things to maintain order in that room. And it also turned out that the case I was trying that day was a property dispute. And if you're from the country, I don't care if it's a foot, it's your foot. And you don't take my foot of ground. Well, it also turned out that I was trying it with a pro se, an older man who was representing himself. So I had decided how I was going to run this case, and to make sure that the pro se was treated fairly, but that I didn't help him too much, that the lawyers were treated fairly, and that we got all this done in this room that was anything other than appropriate for holding court. So we were all in and sitting down, and the pro se person is an older gentleman with bibbed overalls, with really a distinctive face, with the tobacco stains from years and years of use, just a classic face. So I go into the courtroom, I tell everybody be seated, and I start to talk. And as soon as I start to talk, this man stands up and he says, "Little lady, little lady." I've never particularly liked the phrase lady, and when coupled with little, it just, so I said, "Just a minute, sir. You will be quiet," or something to this effect. "Just a minute, sir. I am speaking, and when I finish, I will hear you," or something, probably. So I finished all this stuff about how I was going to handle this proceeding, how I was going to be fair, how I was going to do this, blah, 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 blah. And then I turned back to him and I said, "Now, sir, what is it you wanted to say to me?" And he said, "All I wanted to say, little lady, is everybody ought to love Jesus." So, I mean, yes, it's odd, but what that said to me was, get over your own self, Penny. You know, come on, just relax, be, chill. Don't take yourself so seriously. So we proceeded on with the trial of that case.
Did the case go well following that?
I have no idea. I have no idea what happened in that case. I have no idea.
So, following your brief career as a trial judge,
It wasn't that short.
2 years,
Tried a lot of cases in 2 years.
you next go to the Court of Criminal Appeals. How did that appointment come around?
Well, another fluke, to put it succinctly. A colleague of mine on the circuit court bench, or a colleague of mine who was actually a chancellor in the First Judicial District, suggested to me that I should apply for the vacancy created when Judge John Byers retired from the Court of Criminal Appeals. And there's a nice connection there. I always like to say that Judge John Byers is the reason I was able to become a lawyer and a judge, because he was the juvenile judge when I was growing up. So anytime you even looked crossways at your parents, they would say, "You better straighten up or I'm going to take you to Judge John Byers," and you would straighten up. That was the reputation he had. So he was retiring, and my colleague said, "I really think you should apply for this position on the Court of Criminal Appeals, Penny. There's no way you're going to get it, but you're young enough as a jurist that you need to get your name out there in this nominating process that was then the process used for appellate judges in Tennessee." So I did. I took his advice completely, and in hindsight, I loved the trial bench. I absolutely loved it. I can't say it's better than the Supreme Court. I can't say I enjoyed it more than the Supreme Court, but there is no question that I enjoyed it far, far more than the intermediate court. So it wasn't that I wanted to leave, but he suggested that I should apply, and so he said, "Well, are you that much of a noodle that somebody tells you to do something, you go do it?" I mean, in all honesty, it was also partially about being a woman. That was 1992. Tennessee had been around for 200 years, and we'd had one female appellate judge in our history. And that was Judge Daughtry. At that time, she was Justice Daughtry. And I don't know, it almost sounds too arrogant, but the point is that I felt a responsibility to have women have a fighting chance for some of these positions. And I felt like I really did not feel like I would ever get that position. I didn't want to leave the trial court. I say often, if I hadn't left the trial court, I'd still be there. I'd still be there because the lawyers in East Tennessee liked the way I tried cases, and I liked them, and we got along well, and unless I'd gotten old and crotchety, I think I'd still be a judge. But everything else is fate. I applied. I remember I was so at war with myself about it. I remember talking to my dad on the way down here. The interviews were held here in Knoxville at the hotel downtown, and we were driving down from Johnson City early that morning for the interview. And I had talked to my dad, and I said, "Dad, I just don't know about this." And he told me a story about wanting to work for the United States Post Office and never getting a chance, and then getting an offer after he got on at Tennessee Eastman, and having that pull with himself as to whether to go to the post office or stay the course. And I'm not really sure, I don't think he really advised me withdrawal. I think he probably said to me, do what your heart tells you to do, but for whatever reason, I went on through with the interview and got the appointment.
Was it a surprise to you when you were the one selected?
It wasn't a surprise to me after I made the 3. The
Okay.
fact that I made the 3 was a surprise. What was most surprising about the process is that after I made the 3, I never met the governor. And I do think this is historically important because of where we are sitting here in 2012 and where our courts have come in terms of being politicized. I had never met Governor Ned Ray McWhorter, had never shook his hand. I had never laid eyes on him in a room other than on a television when he appointed me the Court of Criminal Appeals. I got a call from Harlan Matthews, who was his assistant, telling me that the governor was going to appoint me, and that was it. I'm struggling to remember who the 3 finalists were, but I know without remembering precisely, and I don't want to say and end up being wrong, that I was the only one of the 3 finalists who had the three things I had going for me that I think attracted McWhorter, is that I was a female, and McWhorter did want to promote and was being encouraged by many women in Nashville, including Justice Daughtry and Margaret Bim and others, to get more women on the bench. So I had that going for me. I was a trial judge, so I had experience, judicial experience, but more than judicial experience, from the point of view of a governor, I had a position. So once I got appointed to another position, there was a position to fill. And thirdly, I had won by large margins in a very, very Republican area of the state. And here's a Democratic governor who is at a time politically anxious to have even more allies. He had a lot of allies in Upper East Tennessee, but to have even more allies. So he benefited 3 things. Did any of those have to do with my ability to be a good judge on the Court of Criminal Appeals? No. Of course not. They didn't.
So as one of the 3 finalists in this race, you were not interviewed personally by Governor McWhorter or by anyone on behalf of Governor McWhorter?
Not for the Intermediate Court of Criminal, not for the Intermediate Court, no. Never was.
When you got to the appellate bench, did you have to make any significant adjustments moving from the trial bench to the appellate bench?
It is night and day. It is so different, and it was so challenging.
Why so?
Well, the volume of work was completely overwhelming. At the time I went on the Court of Criminal Appeals, we only had 1 judicial clerk each. There were only 3 judges, and given the number of opinions that each judge needed to average each year to keep their docket up, you had to write somewhere between 2 and 3 opinions every week. Now that sounds like nothing unless you start remembering, or you stop and remember, that this is the Court of Criminal Appeals. Every single convicted defendant has a right to an appeal in this court, and the records can range from, well, every single convicted defendant who hasn't pled guilty. And the records can range, obviously, from 1 volume to a room full of volumes. So you might have a record that it takes you literally 2 weeks to read, and then you're already 4 opinions behind. So the volume of work was overwhelming. I had some, I had good, solid criminal procedure thanks to Joe Cook, criminal law background thanks to my practice. So I was not swimming upstream for the subject matter, but I was swimming upstream for the volume of work and the nature of the work, the idea that you're no longer fact-finding, that you're taking facts as found by the lower court, that you're looking at legal issues, but you're only applying precedent, so you're not really deliberating and thinking about what the law should be. You're trying to make sure that you that you apply what the law is. So completely different from the trial bench. And as much as I love him, I had a giant of a colleague who was very, very demanding and very intent on making me the best judge I could be, even if it took, you know, I'm having a vision of him now as a schoolmarm with the little pencil making you rewrite every one of your A's so that they look just like the A's that they're supposed to be. And
Did Judge Tipton actually make you do that?
That's Judge Tipton. No, but what Judge Tipton did make me do once was write 13 drafts of one opinion.
Wow.
So when you say you write 2 opinions every week, that's to stay on top of things. That's not counting rewrites. And Judge Tipton made me a far better appellate judge, but it was arduous. It was completely arduous.
Were you traveling?
We traveled some. You know, Tennessee has a unique system in which the judge on the appellate bench gets to have a chambers in their home county. So I did not move my home to Knoxville. I remained in Johnson City, and I had a chambers in Johnson City. We traveled at that time. We sat, I think each judge sat 9 times a year. I think the court may have sat 10 or 11, but in any event, we probably traveled no more than 6 weeks a year, because at that time the Court of Criminal Appeals would interchange between Middle and West Tennessee, but still, if you're sitting 9 or 10 times a year, you're still in your home district, at least 3 of those, so you're probably only traveling about 6 or 7 times a year.
Did you find that your experience as a trial lawyer or a trial judge really make you more empathetic to the litigants who appeared before you?
More empathetic. I've thought about that. I don't really think that would be an emotion it would cause, or that it caused me personally. I think that you have to struggle as an appellate judge not to rethink what the trial court did. And I think that people who become appellate judges without ever being trial judges have an even more difficult situation, because they're more inclined to want to substitute their judgment. I think being a trial judge is a good prerequisite to being an appellate judge, because it clearly gives you a greater appreciation for the difficulty that the trial judge is in. I mean, like they like to say, the trial judge is, you know, calling balls and strikes as fast as you can throw them, and the appellate court's sitting there for a week wondering whether it was a ball or strike. So I think if you've been a trial judge and you go on the appellate bench, you have maybe a greater empathy for the trial judge and why they might make certain rulings that seem incorrect to you as an appellate judge. But I don't really think the litigants, that it created any great sympathy or empathy. I mean, I already have too much of that. I probably couldn't be any more sympathetic or empathetic than I am.
Sometimes does the fact that you really practice criminal defense law, did that make you perhaps less sympathetic to some of the
Yeah, I think it can have
litigants?
that effect, for sure.
Because?
Well, I mean, you know, the system is fallible, and I have many cases, at least more than a few, where the system failed in that the defendant was wrongly accused. But I also have cases where the system failed because the defendant was wrongly acquitted. So.
Do you ever feel a sense of frustration in reading the record sometimes that maybe the lawyers didn't exert as much effort as that you wish they had?
That was a completely horrible experience. I remember just dramatically the first time I sat on a special workers' compensation panel. I was on the Court of Criminal Appeals, and at that time the Supreme Court was beginning to use other appellate judges and trial judges to sit on workers' comp panels to help reduce the workers' comp load. And the first set of workers' comp briefs I read were like A-plus papers in comparison to the briefs of individuals who had life sentences and 30 and 40 and 50-year sentences filed by maybe overly taxed or maybe just not appellate quality lawyers who were representing defendants on appeal. So the quality of the lawyering, both on the record, reading the testimony, and also in the briefs, could be something that can really frustrate you. It's even more complicated in the criminal setting because you have to worry about every convicted accused following up with a post-conviction case challenging their lawyer for ineffectiveness. So if you're on the trial bench, you're really frustrated if the lawyer is not providing effective assistance. But yeah, that can be a real difficult challenge to not want to suit up for the side that didn't put out their best effort for their client.
Other than Judge Tipton, who were your other benchmates on the Court of Criminal Appeals?
Just Judge Wade, now Chief Justice Gary Wade, when I was there. There were only 3 at that time. It became a 12-member court, 4-member district court in later years.
Do you have any good stories about your experience at the Court of Criminal Appeals that you could share with us?
Yeah, I will have to tell you a Judge Byers story. Now, he retired, but he continued to sit as senior judge. So the first time that I went to sit here in Knoxville, we were in the robing room. It was Tipton and Wade and Byers and me. And Justice Byers said he was there on my first day because he wanted me to make sure I understood the court's protocol. And he undertook to tell me that as the newest member of the court, that it would be my role, and then he starts to go down this laundry list of things, and they get more and more egregious. So he starts with, to come in the robing room first, and to make sure that the briefs have been delivered by the clerk's office, and to make sure that the coffee's out, and to make sure that the coffee cups have been filled for each judge, and to make sure that the hotel reservations have been made when we go to other places, and to make sure that the judge's luggage is removed from their car. So he goes on, and they're all 3 just not looking at, not even cracking a smile. And so finally he can't contain himself any longer, and that was a nice welcome to the court. But anything justice I do remember a case, a funny case, in which the defense was in the trial court that the defendant was entrapped to sell drugs to a woman because of the way she was dressed. She was dressed provocatively. And so she entrapped him to sell the drugs. And I had fun with that opinion, and Justice Wade wrote me a letter and made a nice comment about, I said something like, it would take more than a beautiful woman in a seductive costume to make, make the defense of entrapment. But it was cordial. It was very cordial. It was hard work, and Judge Tipton had high expectations, and Justice Wade had high expectations. But it was cordial, and I was really proud to serve with both of them. They both taught me a lot.
2 years after moving from the trial bench to the appellate bench, Governor McWhirter appointed you to serve as a member of the Tennessee Supreme Court. Tell us a story about how that happened.
We were at a judicial conference it was October, so my guess is would have been Fall Creek Falls. I had left the judicial conference to fly to Maine or Vermont, Maine I think, to teach. I had become very active in judicial education through the National Judicial College and would frequently go to other states to teach judicial education programs. And I had flown there at the end of our judicial conference, actually a little before ours was over, to teach for a three-state program up there. When I got there, I had 2 phone messages at the hotel. One was from then Judge Wade, and the other was from Justice Daughtry, then Judge Daughtry, because by then she was on the 6th Circuit Court of Appeals. Both of them said, "Call me immediately." As it turned out, right as I had flown out of Nashville to Maine, Justice Charles O'Brien had announced his resignation from the Tennessee Supreme Court to go and work on a political campaign. To everyone's complete shock and surprise, as I understand. I wasn't there, but as I understand, everyone was surprised. Both of those phone calls to me were inquiring, or perhaps prodding, whether I wanted to be or would be an applicant for Justice O'Brien's seat. As I recall, I reached Judge Daughtry first, and she was very encouraging. And at that time in our history, Judge Daughtry was the only woman who had served on the Tennessee Supreme Court. And when I went on the Court of Criminal Appeals, she had been the only woman on the appellate court, and when I went on the Court of Criminal Appeals, I was the second woman. So she had been a kind of a role model, although we had never served on the same court together. She had still been a kind of a role model, and Judge Daughtry is largely responsible for the tripling or quadrupling of the number of women judges in Tennessee, she and other women in Nashville, in and around Nashville. So she was encouraging. Judge Wade, I think, was exploring to see, to be the kind of gentleman that he is, the kind of diplomat and gentleman that he is. So within about 20...
Think he might have had some interest himself?
I'm sure he did. He was very qualified.
Yes.
And of course, he knew Governor McWhorter, and I didn't. And I don't like that old saying about how you become a judge, but I mean, we have to be honest about some things, so, about all things. So anyway, within about 24 hours, I had decided, yeah, I'm going to go for it. And honestly, unlike going from the trial to the Court of Criminal Appeals bench, I was open to a different kind of life than I was having on the Court of Criminal Appeals. And I realized I'd just been there 2 years, and I was getting better at it, and I did have a lot of other outlets of professional development as on that intermediate court. But the workload itself and the nature of the work itself was not my favorite. So I applied and went through the nominating process again, made the final 3 again. This time I did meet the governor. He interviewed each of the I understand he interviewed each of the candidates individually, and then he made his selection.
Do you remember who the 3 candidates were?
Justice Holder, myself, and Chancellor Richard Ladd from Sullivan County.
Do you recall now who your fellow justices were when you were appointed?
Absolutely. I sat with, when I started, it was, let's see, we changed twice, but Chief Justice Riley Anderson, and later, before I left, Chief Justice Adolfo Birch, Justice Frank Dwoda, and Justice Lyle Reed.
We talked a little bit about your transition from the trial bench to the Court of Criminal Appeals. What type of transition was it from the Court of Criminal Appeals to the Supreme Court?
In most regards, easier, although there were administrative differences, obviously. The court managed, directed many boards and commissions, so there was an administrative workload that was different, one that I had not had on the Court of Criminal Appeals. The caseload, the volume was drastically reduced, the Supreme Court being a court that takes cases generally based upon their discretionary decision to do so, not an automatic appeal. The deliberative process was was wonderful and much different in that the Court of Criminal Appeals, many lawyers submit their cases on brief, and so the cases are just distributed and an opinion's written and they're circulated through the mail and people decide whether to agree with them. But in the Supreme Court, every case is argued, and the deliberation is, the oral deliberation between the justices is more, I thought at the time, for my 2 experiences, it was more robust, more challenging, more exciting, more invigorating, all those sort of things. And then the learning curve was to remember that the court was not an error correction court. And Frank Drewota would probably like to have $1 for every time he reminded me of that Penny, we are not an error-correcting court. And I would come into the Rule 11 conferences. Those are the conferences on which the court's deciding whether to take cases, and I would say, but this is wrong, or this did this, or this judge did this wrong, or this whatever, and they would say, Penny, we are not an error-correcting court. So that was the learning curve, to remember that the Supreme Court had to be selective in the cases it took and should only take cases that were, policy-driven.
As a justice on the Supreme Court, what's the collective process for deciding that it's time for the law to evolve and to overrule or sharply diverge from previous precedents?
The collective process, that's a, I think, let me speak abstractly and then I'll tell you why I say it. I think that it is, in my experience, it was less deliberate than the question would imply. To say what is the collective process for deciding that it's time for the law to evolve suggests that it's deliberate, that the court sits around and says, we got a problem with tort law, we need to take it in a new direction, or we've got a problem with this, we need to take it in a new direction. That may happen. It may have happened in Tennessee. But in the short time I was there, that was not at work. I came after comparative fault began. But I do think that how the law evolves and how precedent is changed is a function of having a collaboration of opinion, or having people of different backgrounds, of different experience levels, of different practice backgrounds and different personal backgrounds, who hear about a problem and a light bulb goes off, and maybe it's not a collective decision, but someone says, why is it this way? Or, well, when I did this, we did it this way. And so then the wheels start spinning and people start talking about whether the way we've always done it is correct. And I think that's why diversity on a bench is so important. And I don't just mean, the obvious kinds of diversity, gender, ethnic, cultural diversity, all kinds of age diversity, all kinds of diversity is so important, because that's what spins those wheels differently. I had two cases that I think, if people had such a limited period of Supreme Court jurisprudence to my name, but while there, I did have two cases that were fairly significant, that if you looked at, you might say, the law evolved here. Okay, so one was McClung v. Delta Square, which involved liability for the acts of third parties, acts of violence of third parties against victims in commercial parking lots, to be specific. And then Sprint versus Megan, which was a class action case in an eminent domain context. So in both of those two decisions changed the law from what it had been before those decisions. But either by virtue of some questions asked in oral argument or our initial deliberations, and then the opinion was randomly assigned to me, then I do my research and I start looking at it and I start seeing what other states have done and I start thinking about it, and I propose a written opinion. In both of those cases, I do not have any, I would have a recollection if it happened, so I shouldn't say I don't have a recollection. What I would say is that there was no collective process of deciding the law's going to change. We may have all been individually thinking that at one time, but I think what prompted the discussion of the law changing was the draft. So in my experience, there was not an orderly, deliberative, okay, here we've got a problem with the law, let's move here, or let's move there. It seems, I have students who work in the Supreme Court now, and so as a result, I'm able to, I force myself to keep up with what they're doing, and it does seem like the sophistication level of our state Supreme Court, and I don't know if sophistication is the word I mean, but I think it is different than when I was there. So maybe there is someone who you will interview who can answer that question more directly. But in my experience, it didn't happen.
Give us a little glimpse behind the curtain without revealing things that you're not
Sure.
supposed to reveal. You know, in today's society, people just don't seem to want to hear ideas that aren't their own. When you're in conference with your fellow justices, how did that go? Were you open to sharing ideas that weren't your own?
Yeah, boy, that was the intimidating part from the beginning. I'll have to say, Chief Justice Anderson was chief when I started, and he almost without exception started discussions with me. I mean, not only did he make it clear that I had a 1/5 and equal voice, but he made it clear to me that I better be prepared to defend the position I took, because I was not going to be able to latch on to what someone else said. So I found my experience to be collegial, to be respectful, without always being in agreement. I have said publicly, and I don't think there's anything wrong with saying this, the court had been divided a bit before I came. At least the rumors were that it had been divided, and I felt that we were clicking as a fivesome. I did some things that some women would have found inappropriate. I like to tease my four fellow justices about their ties. I like to break the ice in our deliberation meetings before we got started talking. So I had a tie contest, and I can tell you for the record, Frank Dwoboda never won. His ties were just not. Nobody's ties would compare to Justice Birch's, but but in any event, I did things like that. So I felt like we had kind of a good interaction. So behind the curtain, I guess I would say it really depends upon the individual members of the court. You only have to look north in the country to what's going on in the Wisconsin Supreme Court to know that not all multi-member courts function in this capacity. I mean, they are at the point now where they have to have their meetings recorded and viewed because of the animosity between different members of the court, and different members of the court have sued one another and so forth. So it depends upon the members of the court, and it depends on the Chief Justice and what kind of a tone and tenor the Chief Justice sets.
And who was the Chief Justice during the period of time when you were there?
First off, Anderson, and then Chief Justice Anderson, and then Justice Birch. And you know, one of the regrets in my life, I've got a few, but one of the ones, I have this wonderful recording, I can say it. You know, I had been selected as chief to follow Justice Birch. We had made that decision, the court had made the decision to decide in advance so that we would avoid the potential problem that might happen if there was kind of a competitiveness for Chief Justice. So Chief Justice Birch became Chief Justice, and I would have become Chief Justice in November of '96. And that to me, certainly it could be written up as my turn. It had just become my turn. But it meant a lot to me in the spring of '96, which was less than 18 months after I'd got there, that my colleagues had seen enough of my work and me as a person that they were willing at that point to go ahead and vote for me as Chief Justice. Obviously that never happened, and we got a female Chief Justice like 10, 11, 12 years later. But that is one great regret, that I did not get to fill that role.
Today, the Supreme Court justices frequently meet by teleconference.
Oof.
When you were on the court, did you teleconference or did you meet in person?
Drove to Nashville. I drove to Nashville. Everyone drove to Nashville. And yes, that's cumbersome, but boy, I think I don't know. I don't want to judge a process I've never been a part of, but I certainly felt that if I were talking about something that was important for me to get my point across, it was beneficial to be in the same room. You know, we also had a rule at that time, and I think many courts have this rule, that we only talked when we were all together. So that we did not, if we were if we were in our offices and we had a problem with an opinion, we might write a note, or today write an email or something, but everyone would have a copy of that. So I would not go to one judge's chambers and try to get that judge to agree with me on an opinion when the other three members weren't there able to hear our discussion and participate in it. So I also think that's another rule that leads to a more fair and collegial body.
How about your relationship with the rest of the bar as you moved up the ladder on the judicial bench? Did you find that your relationship with lawyers changed?
Well, I mean, it's a sad commentary on human nature, but I mean, you're everybody's favorite, and then when you fall, whew. But no, I mean, my relationship changed in that people were kinder, I guess, nicer. I was always a desired speaker. Come to our organization, do this, you know. I guess I didn't sense it at the time. I mean, I said that the court had a number of boards and commissions, and I was involved in some of the most active boards and commissions. So on these boards and commissions were lawyers from all over the state. And, you know, I just assumed I was forming lifelong relationships with all those people who were on those boards and commissions. But, yeah, I mean, it changes. People should respect the members of the court. But one of the things that I you know, struggle with is the people who change their impression of you just when your title changes. I don't find that a very endearing quality in a person, to treat someone differently when they can no longer help them get somewhere.
Right. Did you perceive any sense of isolation from members of the bar because you were separate and on the bench? Yeah,
I think that there is isolation. I was so busy, I never really felt it. If we weren't, you know, in conference or hearing cases, then because so many things happen in Nashville, all of the boards and commissions meet in Nashville, all the activity in Nashville. I was traveling to Nashville a lot. I was living in Nashville some of the time. I was living in Tri-City some of the time. So I didn't feel that sense of isolation, but let's also keep in mind it was a short period of time. I'm sure that judges who sit for 15, 20, 30 years really, really do miss the interaction that they could have with members of the bar.
Well, it was a short period of time, but would you say that before State versus Odom, you enjoyed your time on the Supreme Court?
It was a wonderful experience. It's hard to say whether I would do it again knowing what the outcome was going to be, but I think I probably would. It's such a wonderful opportunity to get to really think deeply about the law and to have an impact on the law in more than, you know, an individual case. And just the decision making with 4 other people is a challenge and an opportunity. I mean, because you can make better decisions with 4 other people than you can make on your own if you all take the time to share one another's points of view. You can grow from that and make a far better decision than you could make individually. It's harder, but it's in the long run, it's just a much richer decision.
We're going to talk about State versus Odom for a little while, but before we do that, why don't we take a short break so we can make some technical adjustments, and then we'll come back and talk about it.
Thank you. State versus Odom was a capital case, which the Tennessee Supreme Court heard the first time back in late 95, 96. It was a horrendous factual case. It involved the murder and rape of a more than 80-year-old woman who had been visiting her doctor for an examination and who was accosted when she entered her car in a parking garage. Mr. Odom was tried and convicted of capital murder, and the jury in the subsequent penalty hearing, in the capital trials have two phases, both first the guilt and then the penalty hearing, was sentenced to death. The appellate issues that came before the Tennessee Supreme Court, the ones that are most relevant to this discussion, involved an evidentiary ruling that the trial judge made in the sentencing or the penalty hearing, in which the trial judge excluded testimony by Mr. Odom's psychiatrist. The issue in a death penalty sentencing phase is whether the aggravating circumstances, which are specified by law, outweigh any and all mitigating circumstances, which are not limited by law. The Constitution mandates that they not be limited by law. And in a sentencing proceeding in a capital case, the statute also specifically relaxes the evidentiary rules and in particular allows the admission of hearsay. The trial judge disallowed the psychiatrist from testifying in the penalty phase under the theory that it would be hearsay because he had talked with Mr. Odom and other members of Mr. Odom's family in order to arrive at his opinion. With all respect to the trial judge, I usually describe that ruling to my evidence class as an evidence error so egregious that a first-day evidence student wouldn't make it. For one reason, experts are always allowed to rely upon statements of others that they use in determining their diagnoses. And for another, the statute clearly allowed the admission of hearsay. Be that as it may, the trial judge excluded that evidence. So on appeal, Mr. Odom's, again relevant to our inquiry, Mr. Odom's lawyer argued that that evidentiary ruling was error, that it therefore deprived Mr. Odom of his right to put into evidence mitigating circumstances and therefore affected the balance that the jury would have to make in weighing the aggravating and the mitigating circumstance. And the more purely legal question, which divided the court 3-2, was whether, in light of all the evidence in the case, the state had satisfied its burden of proving that the murder fell under the aggravating circumstance that's known as heinous, atrocious, and cruel, so-called hack aggravator. So the Justice Birch authored the Odom opinion, in which three of us agreed that the evidence as presented was not sufficient to prove the hack aggravator and that the evidentiary ruling was an error and therefore remanded the case for a new sentencing. The lawyer had, as is always true in capital cases, argued for the complete elimination of the death penalty on constitutional grounds, had also argued for the reversal of the conviction of Mr. Odom. So really, in some ways of looking at it, the remand for a new sentencing hearing was a fairly modest victory, if you want to use, if victory has any place at all in a capital case, if you want to use that word. But nonetheless, it was a ruling that resulted in the state having to try Mr. Odom's sentencing again, having to go through the sentencing again. The other aspect of the Odom case that fits into the analysis of the heinous, atrocious, and cruel aggravating circumstance is that the state bore the burden of proving that by legislative dictate. And because capital cases are to be reserved for the most compelling of murder cases, what the U.S. Supreme Court sometimes refers to as the worst of the worst, it is not true that every vicious murder necessarily is appropriate for a death sentence. So in attempting to say that in the majority opinion, in hindsight, I now think that we should have been more careful, because what Justice Birch said was this case does not fit within the worst of the worst. Using that phrase that capital lawyers know, that judges know, but that does not communicate well with the media or the public, particularly when you are talking about a person as innocent as Ethel Johnson, and I did not look that back up last night. I'll never forget her name, the victim in the case. As innocent as she was, to say this is not the worst of the worst is not, it's just one of those places where legal jargon and lay jargon don't coincide.
It was a term of art that didn't really fit what the public would perceive as being the right definition.
And it made for a good headline. And so many, and I emphasize that for a reason, weeks after that opinion was released, the Nashville Banner began a campaign, I don't know any other way to characterize it, to oust me based upon that decision. And one of the early headlines said something like, "Court holds rape murder of elderly virgin is not cruel." And I am almost precise in that memory of that headline. From that day, from that beginning on, it was an onslaught against me for the 6 weeks that remained from that Odom decision until my retention election, which was set for August 1st, 1996.
You say the newspaper began a campaign to oust you, and yet you were not the author of this opinion in which 2 of your colleagues joined. Am I correct about that?
That's right. And that's why I emphasize that this happened weeks after the Odom decision came down. Ostensibly, what drew the media attention was a petition to rehear filed by the State Attorney General's office. I say ostensibly because there are a lot of things about those 3 months in 1996 that remain a mystery. There are some things that seemed one way in 1996 and that now I clearly know were not. But that was ostensibly what brought it to the newspaper's attention. The point I'm making is that when the case came down, there was no media attention whatsoever. So, I mean, you asked me about the case, and I unfortunately, for the people involved in the case, jumped into a discussion of how it affected me, and that's a bad thing that I just did, because the case itself obviously has its own actors and its own victims and people that is important and significant, separate apart from how it played into the 1996 retention race. But we remanded the case for a new sentencing based upon those 2 rulings, which basically meant, and I think this is important, and it got lost, a lot of the details of Odom got lost in the media's rush. But what it means when you remand a sentencing for a capital case, and when you tell the state, we don't think 3 of us don't think you've sufficiently proved the hack, what that means to any good lawyer is, hey, I better scramble a little bit and get a little bit more evidence together before this new hearing. In many ways, the Odom decision was a map for the district attorney to do it right the next time. We didn't say no death sentence, we're going to sentence this man to life. The court has done that on occasion. We could have done that. Or we didn't say the death penalty hack is unconstitutional. Many states have ruled their heinous, atrocious, and cruel aggravating circumstances unconstitutional. We didn't do that. We were asked to. We didn't. So in most ways, it was a very modest decision. And that's why you have to look at it with the vision of post-event history and realize that Odom was nothing more than the most convenient vehicle those who wanted a seat on the Supreme Court could use to get one. And I say that very carefully. I'm not saying those who wanted rid of me. I am not so vain to think that I personally had anything to do with it. All I had was a seat, and it was the easiest and quickest seat to get because I was standing for retention and no one else was.
Now, that brings me to a point. Because this is a history project, and we're not sure in the future exactly what the situation will be in
Right.
terms of what the procedures are at the time somebody is viewing this. Could you explain briefly what a retention election is and how judges would get ousted at the
Right.
time you were ousted?
Yeah, so the retention vote in Tennessee requires that one more than half of the number of people who vote yes in order for a judge to retain their seat. So whenever the election term is up, or whenever the judge is standing for retention, the ballot reads, should Justice White be retained as an Associate Justice of the Tennessee Supreme Court? And the voters vote yes or no. And in Tennessee, the rule has always been that it takes just one more than 50%. Some states impose a higher percentage than that, actually, but we don't. So on Election Day, voters vote yes or no. And based upon that vote, a judge is either retained or not. I was sitting in a unique position because I was the first, what I'm going to call, not with any intended compliment to myself, but under the common way that it's called, I was the first merit-selected judge to stand retention. Now, Justice Birch had stood retention, but he was not merit-selected. Justice Birch was appointed right before the Tennessee Plan became applicable to states, to the selection and the filling of vacancies for state Supreme Court justices. So I came onto the court via the the Judicial Selection Commission and the so-called Merit System Tennessee Plan. And then I stood for retention as quickly as I did because I was filling out an unexpired term. And in Tennessee, if you're filling out an unexpired term, by law, you stand for election or retention, depending on which position you hold, at the next general election. So since I went in December of 1994, I stood on August 1, 1996. The other perfect storm part of my situation is I was the only judge on the Supreme Court to stand on that day, so it was the only name under Supreme Court. And the other, benefit was I was easily distinguishable because I was the only woman. And at that time, I was young. I was younger by 20 some years than my youngest colleague. So I was very identifiable. And so that was the process. And I think that's one of the, I think my defeat is one of the most important advertisements for retention elections, because it proves that if you want rid of a judge, you can get rid of a judge. Those who tout elections, partisan or popular elections, rather than retention elections, often argue that retention elections are such down ballot, they sometimes call them down ballot or low voter interest races, that everybody gets retained, and so that they're tantamount to a life appointment. I'm exhibit number one that is not true. We now have at least a dozen exhibits, including the 3 members of the Iowa Supreme Court who were not retained 2 years ago. We have Justice Lanphier in Nebraska. We have the 3 members of California. Certainly, that's not a lot of examples, but you can remove a retention judge. And I would argue that it is harder to run against nobody than it is to run against somebody. I got beat because people believe that anybody would be better than me. I could not contrast myself with some other candidate who might be less qualified, who might have skeletons in her closet or his closet. I had to run against nobody. And I like to tell people that, I managed to lose to nobody. But the truth of the matter is that a retention race is sometimes harder to win than a straight-up race. So these people who claim that retention elections are bad because they're the equivalent of a life appointment, I think that's a bogus claim.
So, in the ideal, the way retention elections were designed in Tennessee at that time was you go through a merit selection process, you're serving a term on the court, which is an 8-year term.
Right.
And then at the end of that 8 years, the voters decide whether they want to retain you as a judge or not. but because you followed Charlie O'Brien and filled in for his last 2 years of the term that he was on,
That's right.
you immediately came up for a retention election before anybody really knew who you were. Is that fair?
Yes, that is fair, and I think it's. I think we have to let's get the historical record straight. No one had ever been challenged. Although the Supreme Court had not been a retention court, the Court of Appeals had always been retention courts, or at least in recent history had been not always. I won't say that, but in recent history had been retention courts. No judge who was a retention election judge had ever been challenged. It was so accepted that a judge would be retained that judges did not have treasuries. When the attack against me began on June the 13th, and I'll never forget that day, 1996, I did not have a treasurer or a treasury. No one anticipated that I would need to run a campaign, and it was so unheard of that we thought it was basically unethical for a retention judge to run for their retention. So at that time in history, none of our justices would be so ill-prepared today because, fortunately for them, I've prepared them. They know better than to get caught, get blindsided. But at that time, it was completely unexpected.
At what point did you recognize, was it when that Nashville Banner article came out, did you realize immediately then that you may be in trouble?
Well, yeah, in fact, and this is also kind of goes back to the code of the hills or the culture of the hills. I am a very worrisome person. I look for things to worry about. One of my friends tells me I will get the gold medal in worrying. So I was worried long before that paper, to the point that I had voiced it to my colleagues and that I had sought advice from a law firm that did some political consultations in Nashville to be prepared. And everyone said the same thing to me: you have nothing to worry about. Don't worry about anything. You have nothing to worry about. When the first newspaper hit, and I think this is a story worth repeating for history because it's funny given the world we live in today, but the court was at Park Vista, what was then the Park Vista Hotel in Gatlinburg, along with the entirety of the Judicial Conference in the mandatory June Judicial Conference meeting. And we had a mixer with the TBA of some kind here in Knoxville, and we had driven from Gatlinburg to Knoxville for that mixer and went back up the mountain. And when we got back up the mountain, I had a voicemail from Sue Allison that said,
Sue Allison was?
Who was the then press agent or public relations person for the court. And she said, Justice White, they've started a Just Say No campaign. I don't know the specifics, but I'll get with you in the morning. That was a Wednesday night. That Thursday morning, it was Thursday night. That Friday morning, the five of us, Justices Drewota, Anderson, Reed, Birch, and myself, were gathered at the coffee station at the Park Vista awaiting Sue's trip to Knoxville to find a paper, to bring it up there to show us. We had no idea what was involved, what case I was being criticized for, we knew nothing. We were completely oblivious to well, let me put it this way, I was completely oblivious, and if any of them had I know them, and I know their integrity, and I believe they would have told me if they had known. None of them let on that they knew anything. So the paper comes up and we see and again, as soon as I say that, I'm thinking, well, here's my naivete coming back out. Maybe they did know in the backs of their head. Maybe some of the judges, maybe Justice Anderson or Justice Drewota knew, and in the back of their head they were thinking, boy, this is going to come down on those three, but nobody ever spoke that if they knew it. And I have reason to trust that they didn't know that. But in any event, the paper came and we saw the headline. And that very day, then Judge Wade was leading an assault on Mount LeConte with a number of us. So we look at the paper, and my insides are churning inside out, and I went and I climbed Mount LeConte that day and worried about it all the way up, talked with him about it, and talked with a lot of people who were doing that hike. And the common thread was, it's a one-day story. It's a one-day story. I have to say that I had the same sinking feeling I had earlier that year when I had sought consultation with a firm with political expertise. I didn't feel it was a one-day story. If you asked me on that day, did I think I was going to lose? I knew it was a possibility, but it just became really clear after the media would not let up. It was not a one-day story.
Sue Allison came and said they've started a Just Say No campaign. Who was they?
Well, it turned out that they was the Tennessee Conservative Union, comprised of two gentlemen in Chattanooga who took most of the credit for it. At least that's who the they was. But in reality, Charles, history and research have helped me to learn that they were just the front guys. They were the Republican Party. They were the new Sundquist administration. It was the Sundquist administration desire to have a seat on the court, and my seat was the seat to get. So the Lloyd Daughtry's and the John Davies, who were the Tennessee Conservative Union, were being manipulated in the same way, in my opinion, that the voters were being manipulated. They were out front doing the work for the administration.
Pure political battle.
Complete, nothing but politics. And, talk about not meeting people. The three people who campaigned the hardest against me, the governor and the two United States senators, had never met me and had never had, as far as I know, had no idea about who I was or what I stood for or what service I had given to the state. Yet they all felt very comfortable in telling the voters of the state that I didn't share their values. And that was a real eye-opening political experience.
Hurtful to you today?
Oh, to this very day, as if it's not obvious. Yes, very hurtful.
Once the battle was joined and the battle was well and truly on, did you feel like you were wearing some handcuffs because of the Code of Judicial Ethics?
I did not consider them handcuffs, but I did feel that my conduct was dictated by the Code of Judicial Conduct. Our code at the time said two things. First, it said that a judge shall not comment on a pending or impending case. And secondly, it said a judge shall not announce views on a contested political or legal issue. It is so ironic that and let me wander here just for a moment to come back. Well, let me talk about the code and then tell you why it's ironic. So now, the part of the code that says a judge shall not comment on pending cases was changed. Really, in 1997, our court changed it to say may comment on a pending case so long as it's not likely to affect the outcome. But at the time I was on the bench, it said shall not comment. And I really did feel like a role model. I felt like it would be really wrong to stand up as a judge on the high court of a state and violate the very fabric of that institution's integrity. So I took that very seriously. I took that shall not as a shall not, and I did not comment on the case. The other part of the rule, the other part of the code that played in, the announcing the your views, what consultants told me is, can you say you support the death penalty? Will you just say that? If you will just make an impassioned plea to the voters that you support the death penalty, we can save you from this. That part of the code also said you shall not announce your views. At one time, the closest I ever came, and I didn't feel that good about this, but the closest I ever came to announcing a view is to say, I took an oath as a justice of the Supreme Court of the state of Tennessee to uphold the law. The law of the state of Tennessee includes certain processes for capital punishment, and I have taken an oath to uphold that law. I did say that. I did not say I believe in capital punishment. A lot of people would say that I did not say that because I did not. And here's where the irony comes in. Because I did not believe in it. Here's where the irony comes in. My opponents, the people who took me off the Supreme Court, made me oppose capital punishment. I had tried capital cases, and I wasn't fond of capital punishment, but I had crossed that bridge before I became a member of that court. I knew that the day would come when I would have to apply the death penalty, and I had accepted my obligation to do that. What made me an opponent of the death penalty was seeing how it can be used and was used to completely politicize the judiciary. So I have become an outspoken advocate of reforming death penalty processes and of eliminating capital punishment because of my election, not before my election. And the other irony is that very judicial code provision that says you shall not announce views on political and legal issues is the code provision that went to the United States Supreme Court in a case called Republican Party of Minnesota versus White, not me, obviously, Suzanne White, the director of elections in the state of Minnesota. That case went to the United States Supreme Court being challenged as unconstitutional, and the United States Supreme Court found that that code provision violated the First Amendment and that judges should be free to announce their views. And that decision was the beginning of the complete destruction of state courts that we are living in the midst of today. And to me, that's just very ironic that all of those sort of things would come together in one person's life. So I did not speak out much. I did not campaign much at all. I didn't have the money to do that. But I don't think all the money in the world in '96 could have combated, I don't know, maybe I'm selling advertisers and media people short, but I doubt it could have combated the anger and the hatred and the ire that the media created against me in 1996. I often said I couldn't get elected if I pulled the switch on the next execution because of the hatred that was out there.
You sat for 2 years on the Court of Criminal Appeals and for 2 years on the Supreme Court. Did you ever have a case where the death penalty was upheld?
Yes, on the Court of Criminal Appeals. The case, the Odom case was the first direct appeal death case I'd ever sat on. So let me just explain that very quickly. So in a capital case, after the conviction, the first appeal is the direct appeal. And at that point, when I was on the Court of Criminal Appeals, all direct appeals went straight to the Supreme Court. So I never had the occasion to sit on a direct appeal at the Court of Criminal Appeals. So Odom was the first death penalty case I ever sat on in that sense, which is another interesting fact, how people would know my opinion and that I was an advocate against the death penalty when I never sat on a direct appeal before. However, on the Court of Criminal Appeals, we did have post-convictions. So after a capital case is upheld, the convicted and sentenced, the convicted death sentence inmate will petition for a review post-conviction, generally alleging newly discovered evidence or ineffective counsel or sometimes prosecutorial misconduct, something like that. I'd sat on those cases. Had two. One of them we had upheld death sentence. The second one, the other one had been remanded on some procedural issue, but it had not, I had never obviously sat on a case in which we had either found the death penalty to be unconstitutional or had otherwise given a person a life sentence. Never had I done that.
Upon reflection, in the retention battle, what was your worst moment?
The worst moment was in Memphis. And this is so telling, and I apologize for it, but every time I fly into the Memphis airport, I relive this moment. Because it was at that little McDonald's in the Memphis Airport, there used to be a McDonald's. I'm not sure it's still a McDonald's, and I can't even remember if it was cell phone or public phone, but I called Lyle Reed. I had been in Memphis for the weekend. There had been a huge festival on a Saturday, the kind of thing that people go to when they're campaigning. And I had all but been physically attacked. I had been verbally attacked over and over and over by everyone I would introduce myself to. Most of the people were confusing me with a federal judge in Nashville who had recently set aside a death sentence in a Kingsport case, the Grosclose case, that had been a death sentence that had been imposed like when I was in junior high. And they were like, how could you let that monster out of jail? And these people were really full of hate and anger. And I went back to the airport and I picked up the phone and I called Justice Lyle Reed, who was one of the 5 members of the court on which I sat. And I don't know, maybe, I don't like to think that he and I were closer, but we had a kindred spirit that was different. I had a connection with Justice Reed that was different than my connection with the other justices. And I just said, Lyle, it's over. You know, they are taking me down. And he said, oh, you know, no, they're not. And I said, look, I've run for office before. I know what it feels like when people look at you and you know that they would just as soon physically harm you as complete the conversation. But I was so very, very low. And I don't know why, but that is what sticks out in my mind as the worst moment, the moment when I knew this is it. It's not, and it may have been because I was alone, I was getting ready to get on a plane and fly home, but it was really a low moment.
Sounds almost strange to ask it, but during that whole process, do you have any good or maybe even funny memories of that time?
No, there is a heartwarming moment in it, and it relates to Judge Daughtry. So the election was on a Thursday, which is always true in Tennessee, and historically, maybe we'll change this by the time people watch this, but it's always in August, which is a low turnout anyway, unless you've got some sort of a really good primary, so judges have to worry about that as well. But I am pretty sure it was the Monday before that Thursday, but it could have been the week before. I was in my chambers in Johnson City, and in chambers there was only me and my assistant, Jan Archer, who was with me through my entire judicial career. My chambers was on the 2nd floor. There was no elevator. There were steps with rubber padding. So I couldn't see the steps because there was a wall, but I kept hearing steps after steps after steps, and I was, you know, in my office doing something, worrying. I'm sure it was 3 or 4 days before the election. And finally, I just get up out of my office and I walk out and I look. And I go into the conference room and there's a large conference table and it is completely covered in yellow roses. Many in separate bud vases, some 2 in a bud vase, some 3, some 4, some even 6. Probably, I still have all the vases, probably 60 or 75 vases with yellow roses, all individually signed by people from all over, mostly women, all orchestrated by Judge Daughtry. And of course, the yellow rose is the sign of suffrage, and Tennessee being the perfect 36th, the state that gave women the right to vote.
Got me wanting to cry too, so don't worry about it.
And there they all were. So that was a good moment.
Yeah, I'd say that was a good moment. After more than a decade has passed, in retrospect, what implications did your retention election fight have on the whole larger subject of an independent judiciary?
Well, you like to hope none. You like to hope there was no residual effect. All I know is what lawyers tell me. I'm not privy to many judge conversations. A lot of criminal defense lawyers, I mean, people laughingly say that they hope their case is, you know, they want to get their case tried or on appeal not close to that 8-year mark. And there are a lot of comments, particularly with lawyers suggesting that they need to distance their cases from election year. But, you know, I've had 2 situations that were shocking even to me. And one was as recently as the judicial conference, let's see, so the next race is 14, so it would have been 6. In 2006, I was back at the Park Vista in June speaking to the judicial conference on evidence. And that was the oddest feeling too, to realize I was back in that same building, the same exact day, except 10 years later. And more than one judge, and maybe this was just a figure of speech, but more than one judge would come up to me, "Hey, how you doing?" And I do have to say that they're much nicer to me when it's just judges around and there's no media around. But more than one judge said to me, "I'm just trying to avoid a Penny White episode." Now that scares me. That should never, ever, ever cross a judge's mind. I often said I was the best member of the court to be taken off because I did not have children. I did not have, we had certain members of our court had family members undergoing cancer treatment at the time, so we had people who had needed health insurance. Losing my pension, losing my salary, losing my health insurance was something I could deal with, but people with kids and health issues couldn't. So I often say that, so that I guess technically you would always think about, oh gosh, what would happen if I lose my job? But you should never be thinking about, I've got to rule a certain way to avoid a Penny White episode. That's very frightening to me. And the second thing is, and statistics are not always telling, but there has been a statistical study done about the amount of cases, the number of cases in which relief has been afforded, capital cases in which relief has been afforded by the 90 to 94 court, which was the new court when Chief Justice Reed, and then the 94 to 96 court, and then the post-96 court. And if you look just at the numbers, you could draw a conclusion that there had been an impact. I don't think looking at numbers tells you what the details of a case are, so I don't put that much faith in those cases or in those numbers. I have much more concern about the individual judges who will confess to thinking about how they rule in concern for whether they're going to stay on the bench. And so the overall, so that's the negative, and Penny White has a tendency to be negative. So let's go to the positive side. I have had, in 1996, the word judicial independence had probably never crossed my lips, nor maybe any of the lips of judges in this state. And in the 15 years or whatever it's been now, I personally have spoken in almost, it's either 38 or 40 states on the topic of judicial independence. And I know that the Tennessee judiciary has had that topic as a basis for its programs many, many times. So judges all over the country, because of what happened to little old me, have had opportunities, the judges who are going to be the tough judges and who are going to stay the course and do the right thing, to think about judicial independence and to try to get other members of other branches of government to think about it. So it has had a positive impact in some ways, and that I think we're talking about it, we're thinking about it, lawyers are supporting it, we're all thinking about the importance of the judiciary in upholding the rule of law, but it also has had that may have had that negative impact as well.
Well, at the time of this particular interview, a major battle continues between those who advocate a merit selection process and those who favor pure elections for judges, particularly the appellate bench. Mm-hmm. With the insight that you have gained from your experience on the bench and going through all this process, do you have strong opinions about that subject?
Well, I do, but it's not just as a result of the personal experience, because like I said a moment ago, personally, I might have won that election if I'd had an opponent. And can I just, as an aside, tell you that, or remind you, and let historians do the rest of the research, that at the whole time, maybe this is what you were just alluding to, Charles, and I misheard you. At the whole time I'm going through this election, I'm being sued by John J. Hooker, who's challenging the constitutionality of the Tennessee Plan, and the Tennessee Attorney General has decided that it would be a conflict of interest to represent me. So I'm having to hire out of my own pocket a law firm to represent me, to defend me in Mr. Hooker's state and federal lawsuits. So this is all happening at the same time, and that was one of several precedents that decided that in fact a retention election system is constitutional in the state of Tennessee, which some present folks would like to sort of sweep those precedent under the carpet. But as a result of those experiences, but more so as a result of seeing what the United States Supreme Court's rulings, not only in Republican Party versus White, which I discussed a moment ago, but also in Citizens United, Federal Election Commission versus Citizens United, opening, basically saying that limits on campaign expenditures are unconstitutional. As a result of those two decisions, what has happened in election states is that the cost of judicial elections are skyrocketing. We're talking millions, 10, 12, 15, 20 million dollars to run for a position that pays $150,000 or $200,000 a year. And so, you know, cash is what determines who becomes a justice. And because of that, primarily, I don't see how, or I am convinced that we cannot maintain an independent judiciary if that judiciary is elected, particularly given those two decisions by the Supreme Court.
In 1996, the year of your retention election, you were the recipient of the YWCA Tribute to Women Award. You were the recipient of the Marion Griffin Award from the Association of Women Attorneys. And in 1997, the Bill of Rights Award from the American Civil Liberties Union. How meaningful was that to you at what had to be a pretty difficult time in your life?
Yeah, it helped. It was wonderful, obviously, for women to support me in that way, and for the ACLU to bestow that award upon me. And some of that time is a blur. I hope I express my appreciation to them as much as I should have, because hearing it put in the chronological context that you've done for me reminds me that there were still supporters out there, although I can say it didn't often feel that way. It felt pretty darn lonely. But I'm happy to be reminded of the chronology of that. It reminds me that things weren't as bleak as they seemed.
During this struggle, was part of it learning who your real friends were?
Yeah. Oh boy, it's something else. It is something. I mean, and by this time I was at the ripe old age of 40. I should have learned that before then, shouldn't I? I always say that my 40th birthday, you know, that 40th year left a lot to be desired.
In your case, I'd say that was probably true.
The next decade was a little better, and maybe the next one will be even better. Who knows?
Well, let's talk about that. Since 1996, you had just an amazing career as a legal educator. Tell us what law schools you have served since 1996. Can you remember them all?
I sure can, yeah. I went to Washington and Lee, College of Law the first year, and from Washington and Lee, I went to the West Virginia University, and from there I went to the University of Denver, and from there I came to the University of Tennessee, and then for a short period of time I went to the University of North Carolina as a visitor, and then back to UT where I presently am.
You currently serve as the director of the Center for Advocacy and Dispute Resolution here at the University of Tennessee. Have you enjoyed that position?
It is just the best job. It is fabulous. It is a blend of teaching, administration, and serving. I want to call it serving the profession, because we do a lot of low fee, if not no fee, continuing legal education programs that are multidisciplinary, that bring together students and members of the profession, judges and lawyers, and in that way I feel like we serve the legal community, because particularly we gear programming to people who may be solo practitioners or people who may be in the types of practice that don't produce much revenue. So I enjoy it very much, and I love the teaching. My students are what make me get up every morning.
E.E. Overton was one of my very favorite professors when I was at the University of Tennessee, because he was just a delightful man. He was well up in his years when I was here, and just delightful and engaged in the soft shoe and a number of other things that kept students' attention. You are now the E.E. Overton Distinguished Professor of Law at the University of Tennessee. How do you feel about that?
I wish I'd known him, really. I never had him as a professor, and I never knew him. I've heard great stories, and I feel really honored to have the chair in his name. When I first started teaching, I said to myself, if they'll just let me teach, I'll never ask to be tenured. I can't aspire to that. I'll never ask to be tenured if they'll just let me teach. And then when I taught a while, I thought, well, I better ask to be tenured. And then I said, if they'll just tenure me, I'll never ask to be promoted. Being tenured will be good enough for me. But then my dean said, oh, you got to go for promotion. So then after I got that and they gave me a chair, I mean, golly, what else? That's just fabulous. But I have heard Overton's stories, and I wish I'd had a chance to know him and have his ability to create memories in his students the way he did in you.
I expect you do create memories in students, but probably not through the soft shoe.
Well, I do have my hearsay pie, which I think shall go without being explained.
All right. As you teach aspiring young lawyers in today's world, what do you view as your biggest challenge in trying to teach the art of advocacy?
The biggest challenge by far is the many challenges that is the challenge that is brought about by technology and by the how technology globally is affecting interpersonal relations. I mean, and by that I mean this. Advocacy is about the ability to connect with people, to connect with your client, to connect with the jury, to connect with the judge, to connect with opposing counsel, witnesses. And I fear and I struggle to help my students understand the importance of connecting with people, not connecting with devices. And it's really more than just the individual connecting with their device. It goes so far, it goes even farther than that. I mean, when we were in law school, Charles, we would bring a pen and a piece of paper or our legal pad, and we would listen and we would process, and then we might make a note. Or maybe people like me made several notes, because I did take a lot of notes. But what technology has done is it now enables the student to, what concerns me is that the students are using such technology that they're not listening or processing. They're transcribing verbatim. Now, and in that exchange, you've got to fight to get that exchange in your classroom, because if you're transcribing everything and you're not processing it, yes, maybe you'll go process it later at home, but you might have had something wonderful to contribute to that discussion that never gets spoken or never gets responded to because you didn't process it. So, I mean, that's just one small example of just getting through to law students that advocacy is going to be about connecting with people. And you're going to learn a lot about connecting with people as you connect in the classroom. And of course, I don't want to say that it's not also about helping remind them that they are asking to become a part of a profession, not a part necessarily of a business enterprise. Yes, we hope they make a good living. Yes, we hope they're comfortable and so forth, and that they create. But it is a profession, and we struggle. I mean, some people would say, join the 2012's Professor White. It's not that anymore. But to me, those are the greatest struggles, to teach them that it's all about connecting with people. And really, that is part of the fact that it is a profession, a professional endeavor. Now,
how do you do it? How do you limit that
not always
over-reliance
that well.
on technology?
No, not always that well. I mean, there's a huge debate in the legal academy now. Some professors ban laptops or ban all sorts of technological devices, and then others say, well, it's no different from you know, they're distracted by the internet. We were distracted by playing connect the dots or whatever. So I have not gone to those lengths. I try really hard to make my classes interesting, my lectures interesting, to not lecture, to engage. In the concentration which I direct, for which I select adjunct professors, many of our classes are 8 and 10 and 12 students. And so in those classes, I'm not at all afraid, or I don't hesitate to say, don't bring your laptop. Like I teach an advanced evidence class right now, and we sit around a conference table and we talk. And so in those classes, it's easier. But in my evidence class, which has 50-some people, there are people there. I'm sure that if I checked all their laptops from this morning, there would be a lot of them that were reading about last night's debate or checking ball scores or something. So it's hard. It is the challenge of modern day education, higher education, to keep students engaged. Now sometimes we can use the technology to engage them. Most of us use technology in the classroom, either from as simple as, you know, slides and PowerPoint presentations to use of clickers, where you ask the students a question and they click the answer, and then the screen shows their responses, so that they are interacting with technology. So I'm not just trying to say, you know, technology's all bad, but it's a struggle.
Technology is our savior and our executioner.
That's exactly right.
So what classes do you teach beside evidence?
I teach evidence. One thing I'm really happy about is I've started and direct the judicial externship program here. We place our first and foremost goal is to serve state court judges, and that was an outgrowth of a Knoxville Bar Association program. So we try to place students in state courts first, primarily here, the criminal courts and the Chancery Court, only because those are the judges who have shown interest. I've also begun placing students with the appellate courts, all the way up to the Supreme Court. We've had students in U.S. Magistrates Court and Federal Court, and we've had students with the Tennessee Claims Commission. So the students work 12 to 15 hours a week in a judge's chambers, drafting opinions, doing other things that are helpful to the judge, and doing a lot of observation of how you act in court, and that in and of itself is a professionalism lesson. I also teach whatever else I need to staff, which could include, meaning that I don't have enough adjuncts, which could include and has included negotiations, interviewing and counseling, pretrial litigation, trial practice, professional responsibility. I don't teach that so much anymore. We have new professors who teach that. Criminal pretrial litigation, and a seminar sometimes on the media's impact on justice. I teach a little bit of everything, but all skills related. So my core courses are evidence, negotiations, trial practice, and the judicial externship.
Penny, you've had 3 amazing and successful careers.
Maybe that's why I'm tired.
You've been a lawyer, you've been a jurist, you've been an educator. Which of those is your favorite?
Oh, depends on the day.
Is it like asking you which is your favorite child?
Yeah, I guess. I don't know. I loved trying cases. I loved appellate argument in the Supreme Court. I loved trying cases. I loved the trial bench, and I loved some of the things about the Supreme Court, quite a few. I like teaching. I can't say, Charles. I've been so fortunate. So I've loved aspects of all of them. I used to say, and I do think this is still true, that I would be a trial judge again, and I would go to the Supreme Court again. I'd probably be a lawyer again. So I guess the only job I wouldn't take again, and my hat's off to them, is that poor, overworked, intermediate appellate court job. So sorry about all the work they're having to do.
Well, we've learned about all of these things you have done in your career. What do you do outside the office? Do you do anything
That's
outside
a
the
bad
office?
one. Well, let's say what I like. I love the out of doors. I love the mountains, and I have a little place up on Watauga Lake, which I do not get to often enough. I have a large extended family in the sense that my sister, I do not have children, I am not married. My sister has 4 children, and her 4 have a combination of 14. So with a little bit of it being yours, mine, and ours. So I do like spending time with my nieces and nephews. I have a few good friends that I love spending time with, and I love to travel. My present situation does not enable travel, the kind of travel I want to do. I mean, I really do want to see the world. I've seen a tiny amount. I've seen more of the world than I ever expected to see when I was in high school or college, but not nearly as much of the world as I want to see. And now I'm very, very involved in taking care of my parents. Mm-hmm. So that's really what's occupying my free time. I don't have much free time right now, but those are the things I would love to do. I like to cook. I'm not a gourmet cook, but I love to cook for people. I'm not a Southern cook either. I don't do biscuits and gravy. I don't do chicken and dumplings, but I like to cook for appreciative people.
Of all the places you've been in the world, if I had a short time, which one would you send me to?
It's changed, but I love the Ring of Kerry and the Dingle Peninsula in Western Ireland. It's grown up much more than it was, but I love that. It's beautiful.
Is there anything else you wish I had asked you that you'd like to tell us about?
Well, you kind of told me you might give me one thing, so there is one thing, and it's more for history. You know, we talked a little bit about selection, judicial selection, and I've mentioned a couple of times that the Supreme Court had boards and commissions. And one of the boards and commissions that I served on when I was on the Supreme Court that ties into the judicial selection retention thing that I think is so important is the evaluation process for judges. And I was fortunate enough to serve with now Justice Bill Koch when we first brought evaluations of judges, judicial performance evaluations to Tennessee. And one of the things that I would hope that history would remember is that Tennessee judges, when it was not something they really wanted to do, stepped up and said, yes, evaluate us. We want to be better judges. We want to improve. And there are 32 or 3 states where that is unheard of. There are only 8 states, maybe 10, where there's any kind of judicial performance evaluation. And so we hear a lot of rhetoric about judges being held accountable. The way to hold judges accountable is through meaningful judicial performance evaluations, evaluations that evaluate things that matter to judging, not which political party or which special interest group can give them the most money. So I hope, you know, as time goes on and people think about how do we select judges, how should we select judges, more and more people will embrace the idea of judicial performance evaluations looking at, and this is not rocket science. I mean, there are a few states that have devised appropriate criteria to look at when you're trying to decide whether a judge is doing a good job. And I'm proud to have had some role in that, with Justice Koch obviously carrying the bulk of the work. He was the scholar on the commission, but I'm proud to have played some role in bringing that form of accountability to the state of Tennessee.
Is it your experience that with the judicial evaluation process, when the judge has the material made available to him or her, that they are willing to modify their behavior consistent with the evaluation?
Many, not all. I think we have bad eggs on the bench, just like we have bad eggs everywhere. And some people can't accept even meaningful criticism as constructive and grow from it. But I think many desire that and want to know how to get better. So yeah, I think many do take that to heart.
My final question to you is, when all is said and done, how would you, Penny White, like to be remembered?
Well, I've thought about this, and that's a wonderful question. It's a wonderful opportunity to be able to answer that question, and I just appreciate the opportunity to make this tape. I hope that it is of some use someday. So how I would like to be remembered? I would like to be remembered as a person who always struggled to do the right thing, even in the face of grave adversity, who struggled to do the right thing. Maybe didn't always get it right, but struggled to do the right thing. And I'd also like to be remembered as a person of passion who when I had the opportunity, gave all I could to help enhance the integrity of the justice process, and have tried to embrace other opportunities to prepare others to fight to preserve the integrity of the justice process. And I guess lastly, as a compassionate person, as somebody who always treated everybody exactly the same, no matter who they were or where they were.
Great way to be remembered. Thank you,
Thank you.
Penny. I've enjoyed this conversation.
Me too. Thank you.